can hear me loud and clear. If I get some nods, that will be fine. I'm just looking around. I'm not sure if everybody who was down for attending is here. I'm not seeing Mr. Hardy. Well, I think what we'll do is we'll wait a couple of minutes, I think, just to make sure that everybody who is attending and participating today is here. I think also the representative from Save Straighten for Scotland isn't online yet either. So rather than starting to backtrack, I think if we wait for a couple of minutes and see if the others eventually log on, then I think we'll do that. So we'll just pause at the moment just to wait to see that everybody else logs on properly. So we'll just wait for a couple of moments. I'm just wondering, is there anybody online? I can't see anybody, but from the Craiginmoddie team, because we don't seem to have, as far as I can see anyway, a representative from Craiginmoddie. So I'm a bit loath to commence if one of the applicants isn't here at the moment. And I take it nobody has any idea where Mr. Hardy may be at the moment. No, I'm seeing all blank faces. Okay, I know we did change the time to 9 o'clock from the original start time, so I don't know whether there's been some confusion. So I think we'll need to try and see if we can make some contact to see constructive bouts of Craiginmoddie. So if you could bear with us while we do that, that would be much appreciated. Yes, Mr. McLeod.
I'm just advised my client was on to Craiginmoddie's project manager there, and I understand they're waiting in the lobby to be let in.
Okay, I will go and check that. That's very helpful. Thank you very much. I will go and open the door and see if we can let them in. Okay, I think they are in the lobby and we're just sorting out a link for them. So hopefully within the next 2 minutes, we should have representatives from Craiginmoddie. So thank you for your patience and we'll just wait till they appear.
It may have been yesterday's link, which is an error I did recently as well. Just clicked on the wrong day.
I can see Mr. Hardy is with us now. Can I just check with Mr. Hardy? His colleagues are also with us as well.
Yes, sorry, good morning. We've had some problems with the link, all three of us in the team, but I'm on, I don't know, Mr. Calvert, is Mr. Calvert on, and Mr. Briggs? I wonder whether you could just wait 30 seconds while if I forward that link to Mr. Briggs, Mum. I apologise.
That's fine. That's no problems. We're happy to wait to make sure everybody is actually here. Thank you.
Thank you. Thank you. Mr. Briggs tells me that he is now able to get on. So I think we're all here. Thank you very much. And again, I apologise.
Oh, that's fine. Obviously, we need everybody here, so happy to wait to make sure everybody's properly online.
Yes.
Okay, so I will commence. So just welcome and thank everybody for attending today's virtual hearing on the draft conditions as part of the conjoined inquiry into the 3 wind farm applications at Craiginmoddie, Carrick and Knockcronal in South Ayrshire. As most of you will know by now, my name is Gordon Reid, one of 3 reporters appointed by Scottish ministers to consider the 3 wind farm applications and to report back to ministers. Mr. Bray and Mrs. Leven are also present today to take part in the proceedings as we move through. I think everybody can hear me and see me. I think all the nods are there. There's a lot of people on screen, so as we move forward through conditions, if you're not directly participating, then if you're happy enough to switch off your camera, that's fine. If you are participating, keep it on so we can see you when you're speaking. So today's agenda was issued on the 6th of June. However, the numbering of the conditions on that agenda was based on the list of conditions submitted on the 7th of April. Clearly, since then, we've had updated a list of conditions, and that was submitted on the 14th of June, which amended the numbers on the conditions. So as a consequence, the numbers on the agenda no longer correspond with those in the most up-to-date list of conditions. So in order to avoid any confusion, if we all work off the numbering contained in the 14th of June list, that's the most up-to-date list of conditions. Ignore the numbers on the agenda. They will just lead to great confusion on my part and probably for everybody else. So if we ignore the agenda numbering and we stick to the references in the 14th of June list, I think that will work. Does that work for everyone? I hope everyone's based their preparation on that. Okay, I'm not seeing any issues with that. That's fine. Okay, just to remind you, I'm sure you're all aware, but the virtual session is being broadcast live. And as with the previous sessions, in taking part today, you're consenting to being filmed and to the use and storage of those images and sound recordings and any information contained in them for webcasting and training purposes and for the purpose of keeping historical records and making those records available to the public. Can I ask everyone to introduce themselves? We'll start with the applicants, and if we can start with Craiginmoddie.
Thank you very much then, sir. Then David Hardy, partner at CMS. And with me, I've got Chris Calvert, who you heard from yesterday. He's the Executive Director at Pegasus. And then I also have Michael Briggs from the client, and I think that all three of us will be contributing during this session.
Okay, thank you. And for Carrick?
Morning, sir. Ewan McLeod from Shepherd and Wedderburn. I've got two colleagues with me today. Mr. Jamie Scott from WSP, who you've met before, and Ms. Emma Moyer, who is a solicitor with Shepherd and Wedderburn, who's been heavily involved in the negotiation of the conditions.
Okay, thank you. And for Knockcronal?
Good morning, sir. My name is Vincent Fraser, King's Counsel. I'm instructed by Pinsent Masons, and I have my instructing solicitor, Mr. Gary McGovern, with me today. With him, sir, we have his associate, Mr. James Gibson, and we also have Mr. Mark Jiggins. It might just help, sir, if I explain. Mr. Gibson has done most of the work with respect to conditions, so I'm effectively going to hand over to him and let him lead us on this matter. Unless Mr. McGovern or I have something to contribute. And Mr. Jiggins is obviously only here to deal with the noise conditions. Once they've been dealt with, I think he'll probably leave.
Okay, thank you for that. And for the council?
Good morning, sir. My name is Douglas Armstrong. I'm King's Counsel at the Scottish Bar and representing South Ayrshire Council. Steve Callan and Nick Lopez from Stantec are the planners today and will be addressing these conditions.
Thank you. And for Glasgow Prestwick Airport?
Thank you, sir. My name's Sarah Wardell. I'm a Senior Associate at Dentons and I'm here with myself for the airport this morning.
Okay, thank you. I've received apologies from Ellen Traynor, who was to be attending this morning but can no longer attend. SEPA have also indicated that they are not attending today but have submitted their comments in writing, which I think were circulated around parties. Just looking for nods if that's correct. Yes, I think that's fine. Now, Save Straighten for Scotland were to be attending this morning in relation to the noise matters. So far, we've had no contact from Save Straighten for Scotland. They haven't appeared in the lobby waiting to be let in. So I think we'll just have to keep an eye on that. I think it was the governor who was to be attending. Once we get to the noise section, then we'll maybe just pause and check. So the purpose of today's hearing section is for us to examine the matters raised in relation to the draft list of conditions. We'll go over the boundaries lead, where we didn't consider further information is required in order to prepare a report. The session will be a structured discussion, and I will lead that as per the headings, but not the numbering on the agenda. I will not allow any formal presentation of cases or cross-examination. Again, I'll lead the discussion by starting off on each agenda item, directing a question at one of the parties. After that, I shall invite other parties to comment in turn if they wish. If you have any comments or questions as the discussion progresses, please make sure you go through me and let the other party finish their point. Even if you strongly disagree with what is being said, please do not interrupt the party. I will leave it up to each team leader to decide who answers the questions for them. The team leaders may also wish to add some concluding remarks on certain points. These again should be focused and brief. Given the different witnesses for the parties, I may just refer to Craiginmoddie, Carrick and Knockcronal, just so I don't get the wrong person involved. So if you are the person speaking for them, then just come in at that point. Again, as we're online, please use the raised hand function within Teams or do it physically if you need to talk or to get my attention. And again, remember to switch off your microphone if you're not speaking. I think everybody should have the core document lists and be familiar with that. So if you have those handy, that would be helpful. And again, if you can refer to the CD number and the electronic page and paragraph number if you're making references. And if you can just read the CD number out quite slowly, so we make sure everybody takes it down. That would be very helpful. Once we feel we've got enough information that we need to write up reports, we will move on to the next item. And again, don't feel obliged to comment if you're only repeating what has already been said or included in the written material before us. I think that's particularly if all three conditions for each applicant are the same. Then if you're accepting of that, if you can just sort of agree that would be helpful. We expect that the matters set out in the agenda will be dealt with during the course of today, hopefully. We will pause for lunch around 1 p.m. Comfort breaks will be taken as we feel necessary as we progress through matters. So we'll work on that basis. You'll see from the agenda that we intend to consider the noise conditions first. The section 36 conditions then move on to the deemed planning consent conditions, and finally any other conditions that have arisen. Given that there are slightly different issues with each case, not all questions may apply to all three applications. Where the issues are the same for each application, as I said earlier, it might be easier if one applicant takes the lead to respond, with the other two either agreeing or otherwise. I know that further progress on agreeing the wording of the draft conditions has been reached between parties and is set out in that updated list of the 14th of June, and that's been very helpful. We will seek confirmation that that is the case as we progress in terms of areas of agreement. Notwithstanding that, we may still have some questions of our own on these conditions, although they may have been agreed between parties. In addition, some further revisions were submitted to the wording of the draft conditions on Friday, the 16th of June by the applicants, and these were in relation to operational noise, and that was from all three applicants. Condition 9, aviation lighting by Knockcronal. Condition 30 on archaeological mitigation by Knockcronal, and condition 17, construction hours, Knockcronal and Craiginmoddie, and most of those were in CD 15.38. Also, condition 36 on decommissioning, site restoration, aftercare for Knockcronal and Craiginmoddie, and that reference in that document, I think, should have been to condition 36 rather than 39, which was the old number pre the 14th of June submission. SEPA won't be attending today, but they had submitted further comments, and that's in CD 15.12, confirming that they were satisfied with the wording of the draft conditions for Craiginmoddie and Knockcronal. However, there were still some outstanding issues in terms of wording some of the Carrick conditions. Further update was submitted last night from Craiginmoddie in relation to condition 13, which relates to micrositing, and that was seeking to address the concerns of the council. So there's been a fair bit come in since the 14th of June, and a lot of that's been sort of the last minute. So what we'll do is our intention to try and consider these further revisions at the relevant points as we proceed through the agenda, rather than trying to deal with them sort of separately. So we've tried to weave them in to where they are relevant as we move through. So the question I've got is, whether the parties have seen and have the opportunity to consider the proposed revisions to the wording of these particular conditions. If anybody's any comment to make at this stage. Mr. MacLeod.
Thank you, sir. I'm not sure whether you've seen it or not. It wasn't one of the updates that you've mentioned, but there is a further submission that's come through this morning from Save Straighten for Scotland related to the operational noise condition. It literally arrived about 5 minutes before the hearing started, so we've clearly not had an opportunity to discuss it. I had a suggestion as to how you might deal with it, and I don't know whether you want me to put that to you just now, or whether you want to wait until we get to the noise part of the agenda.
Yes, we were aware of that coming in. I was going to pick it up under the noise part of the agenda at that point, just how we then sort of deal with it. So if you're happy enough to wait to that point, I was going to wrap it into that because it came in so late this morning.
I am, sir. Thank you.
Okay, that's great. Thank you. in terms of any other the submissions, has everybody seen the relevant ones and had time to consider those? Okay, seeing nods. So before we turn to item 2 on the agenda, does anyone have any procedural questions? It's time.
I'd like to comment.
Yeah, Mrs. Levin.
Just to let you know, Mr. Ovner is trying to join the meeting, so he will hopefully join.
Okay, so that will be helpful, particularly as that Mr. Groffer is involved in the noise section. So moving on to item 2, legal agreements. Are there any legal agreements of relevance to the applications that we should be aware of at this time? Right, okay, Mr. Bray.
I don't know if you can hear me, but when Mrs. Levin was talking there was quite a nasty echo. I don't know if everyone got that. So just to be aware of that.
I think that was my fault with pressing the wrong button. So
I think we may have that resolved now. Mr. Callan.
Yeah, good morning, sir. Just in relation to legal agreement, our suggestion is for a section 96 under the Roads Act to cover pre and post construction work activity in terms of repairs and maintenance, and this will also require a roads bond to be in place and agreed with Ayrshire Roads Alliance, who are the roads authority covering the region.
Okay, thank you for that. Does anybody have any questions on that? Mr. MacLeod?
Just very briefly, sir, whilst we fully expect to enter into a section 96 agreement, we don't think it's something that you need to write on or include by way of condition or anything of that nature.
Okay, thank you for that. Mrs. Levin?
right, I will just start talking and I will not press any buttons, hopefully not mess it up. Yeah, it was just to say, Mr. MacLeod, that was my understanding from the transport hearing.
Yep.
Thank you.
Yes, and same for us, yeah.
That's fine. I just wanted to clarify. Okay, that's good. Thank you for that. We can move on to item 3 of the agenda. It's now been agreed that the aviation inquiry session will now take place virtually on the 4th to the 8th of September 2023. And there are ongoing discussions around the dates of the submissions or preconditions, which we will obviously resolve shortly. As matters may arise during that session that relate directly to the draft aviation conditions, we proposed that at the end of today's session that we would adjourn this hearing. We would then reconvene the hearing session after the aviation inquiry session at a day and time to be agreed with parties to consider the draft conditions directly relating to aviation. This session would obviously include the applicants, council, and any other relevant parties. So in terms of the conditions, that would mean that we would leave for discussion detail until after the aviation hearing. Conditions relating to condition 5 on aviation lighting, condition 6 on aviation radar, condition 9 aviation lighting, condition 10 on aviation charting and safety management, condition 31 on en route radar mitigation scheme. There would also be some elements of other conditions where Glasgow Prestwick Airport have commented on it in relation to condition 13 micrositing, 16 construction and environmental plan, condition 34 redundant turbines, and condition 36 decommissioning site restoration and aftercare. So just those particular elements that would relate to aviation would be left over to that reconvened hearing session. I think that's practical way to try and deal with that, particularly as it would be to ensure today would be in advance of evidence being heard at an inquiry session. So are parties agreeable in principle to that? Mr. Hardy.
Yes, it's just an electronic thing. You are coming in and out of kind of proper reception for us. I don't know whether other people on the call are feeling that as well. It's modulating quite badly. So I don't know. So whether that's a microphone issue?
Right. Can you hear me now better?
Yes, there are times when you're perfectly clear, but then you drop out.
Okay. What I'll do is I'll make sure I don't drop my voice, which may be part of the issue. So if there's another issue, if you just sort of raise a flag, that would be fine.
Yes.
Did you get all of the stuff I've said then, or do you want me to go back over the aviation, or have you got the gist?
No, got the gist of it. Yes, that it's been set back until after the aviation session.
Yes.
After date to be agreed. No, that's fine.
Right. Any comments from any of the other parties? Mr. Gibson, you've got your hand up. See.
Thank you, sir. Yeah, just to confirm that the entirety of the aviation conditions, with the exception of aviation lighting, have been where there's a specific issue with regards green matters with the council. But with the exception of that, all of the aviation conditions for the Knockcronal project that you've cited have been agreed, both with Glasgow Prestwick Airport and with other parties, including NATS. On that basis, it's not our intention to attend and participate in the aviation sessions that will follow.
Okay, thank you for that. I know that the conditions have been agreed between parties, but we may have questions on some of those conditions ourselves. So obviously we need to consider them following the evidence that's submitted in the inquiry session. So we may have further information that we would like to seek or clarification on points. So I would just sort of leave that with you at the moment, that I acknowledge that there has been agreement between parties, but we still need to consider that ourselves. Back to the principle of, is everybody agreeable to adjourn at the end of today, then reconvene post the aviation session? I think I'm seeing nods all around. Okay, and the council happy to participate in that as well, even though they weren't in the aviation hearing? Yes, I'm seeing a nod from Mr. Armstrong. That's fine. Okay, I'm getting a message here. Mr. Grosvenor has managed to get into the link. I'm just trying to see, but it hasn't appeared on my screen as yet. If you could just bear with us a couple of minutes, because we're going to move on to item 4, which is noise conditions, and that is the one that Mr. Grosvenor is to take part in. So if you can bear with me, just check. In the interim, Glasgow Prestwick Airport.
Thank you, sir. It was just to say that not having anything to contribute to the remaining agenda items, I propose to drop off. So I just wanted to check there was nothing further. We're not going to agree the dates today for the aviation hearing. I'm in a position to do so, but if that's not anticipated, we can defer that to a later point. But other than that, I propose just to drop off.
It wasn't our intention to agree the date today, but we will be doing that soon. So yes, if you wish to depart rather than sit through the rest of the conditions, we're more than welcome to do that. That's no problem.
Thank you.
Okay, thank you very much for attending this morning.
Thank you.
Okay, we still don't have Mr. Grosvenor in the lobby waiting. I'm conscious that we want to kind of progress and move on. So I think we just give it another minute to see if we can get Mr. Grosvenor online. And if not, then we will look to proceed. Okay, we still don't have Mr. Grosvenor in the lobby, so I think we need to progress matters. So my intention is to move on to item 4, which is noise condition in the agenda. Are all parties happy with that? Yep, I'm seeing nods. Okay. So following the noise hearing, which took place on the 30th to 31st of May, it was agreed that we would consider the matters relating to noise conditions first of all. This would allow those witnesses who only have an interest in matters relating to noise to contribute to the hearing, and then when finished, leave today's proceedings. Safe State for Scotland are meant to be participating, but only in this session, and hopefully Mr. Grosvenor will be able to get online as we progress through this. Are all parties happy that we deal with all the matters relating to noise first of all, and then that will allow the witnesses to leave once we've completed that? Yep, I'm seeing no disagreement. At this point in the agenda, I will hand over to Mr. Bray, who will take us through the issues in relation to noise conditions. Thank you, Mr. Bray.
Okay, thank you, Mr. Reid. I just want to make sure that all the parties are aware, in terms of the applicants, are aware of what has been submitted by each party. I'm sure you are. 3 new CD numbers: 1535, 1536, and 1537. That's the Craiginmoddie and the Carrick and Knockcronal operational noise condition amendments. Given these documents have come in reasonably late, I would just like to give the applicants the opportunity to talk us through what has been done with the operational noise condition. I'll maybe start with Craiginmoddie, and then if it's exactly the same thing that's been done for the rest of them, then fine. But so that's CD 1535. That's the amendments that have been made to the operational noise condition from Craiginmoddie. If you can just talk me through what's been done and what has been popped into the tables, and the amendments that have been made to the narrative as well, that would be useful, and then we'll have a discussion after that. So over to Craiginmoddie first.
Thank you, sir. So what's happened is that the operational noise condition, condition 37, has been agreed between, or the wording of that's been agreed between all of the applicants. So the wording of that condition is identical, apart from the project-specific information, which is listed in tables 1 to 3. So there is commonality. So we're all aware of that. There's been lots of discussion in the background. So as you say, there's CDs 1535, 36, 37. As you will see, there is a difference between the parties and the council in that the proposed conditions do not include any provision for control of amplitude modulation. There are reasons why that is. You've heard some of those, and it maybe we discuss some of those again. So there's commonality, that is the basic point. I don't know whether you need anything further. So the specific point, if you like, to Craiginmoddie is the insertion of table 1 to 3. So that is related to the particular properties. That is what differs.
Okay, can I clarify that? I mean, I think there are other changes that have been made to the text supporting the tables in the documents. So can I be very clear that all of the supporting text is exactly the same? All the changes that have been made are the same
Correct.
changes for
Correct.
all 3?
Yes.
And
They are all in the same form, apart from the scheme-specific tables.
And just get confirmation from Carrick and Knockcronal then in terms of the changes that have been made.
That's correct, sir. In terms of Knockcronal, the condition is identical to Craiginmoddie and Carrick, save for the tables.
Okay. Carrick, yes, as well. I just wanted to double check that.
Yes.
Okay. All the little typo changes in the text that's supporting, whether it's changing spelling and all the rest of it, is
Yes.
exactly the same.
Yes.
Okay, that's fine. If that's what I want to clarify, I didn't want to go through it all and double check. I wanted you to tell me that you've done it. Mr. MacLeod.
Just one point to note, sir. If you look at if you've got the Craiginmoddie document there, you'll see there's a comparison against the previous version of the conditions.
Yeah.
And if you go to page 10 of 12 of that PDF,
yeah.
In the section headed data collection, there's an addition from all three of the applicants related to the collection of audio recordings, which you'll remember was one of the matters that Save Strafing for Scotland raised at the noise hearing, and the applicants have all agreed to provide that data as part of the condition discharge process.
And that's under item A.
It is, sir. Yes.
Note 1, item A. Again, that's obviously common across all the documents. Okay, I just wanted to be
correct. Yeah.
Absolutely clear on that.
Yes.
Okay. You can assure me that the tables that have been taken over from the statement of agreement, the figures that are in the table, have they changed from the statement of agreement? I'm not going to, or in preparation for today, I didn't check every cell of every table, but
they are
your intention.
Yep, that's the confirmation I can give you. Yep.
That's fine. That's useful. I will check at some point, but I didn't have time in advance. In terms of from the council's perspective, I think the council submitted a proposed operational noise condition, and I think that's at the end of the table of draft conditions that were submitted on the 14th of June. Can I just check from the council's point of view that that's your current position? I think they probably take on board the amendments to the condition that were proposed by ACON back in March. So if you can confirm that condition that's at the end of the table that was submitted on the 14th of June, is that your current position?
Well, obviously the conditions from the applicants have come through fairly late. So what I've done is I've sent on all the conditions that have been provided by the three applicants onto the council, who've then forwarded them on to their noise consultant, ACON. They have come back on Knockcronal and Craiginmoddie, not Carrick yet, because that just came through this morning. And I think they've accepted the conditions proposed both by Knockcronal and Craiginmoddie. I think the difference was that the condition that the council or ACON were proposing included a provision relating to amplitude modulation. We felt, or the council felt, there was a basis for that, but it did go beyond the ETSU guidelines. So on that basis, they've accepted the revised conditions as proposed by Knockcronal and Craiginmoddie. So waiting to hear back on Carrick, if I can provide an update on that potentially later in the session.
Well, that's useful. So you're able to clarify just now that for those two, the revised conditions that we've just gone through are acceptable to the council, and you expect further clarification later on. Mr. Jiggins, you had your hand up.
Yeah, it was only just to assist really with the CD reference. That was CD 015.031, which was the ACON proposed conditions.
Yeah. That's obviously been, if you like, updated just now by Mr. Lopez, who's indicated that the revised conditions have been accepted too, and he's waiting for confirmation on the third. Okay. If that's the case, does the council have any further questions on the operational noise condition before we discuss Save Straighten for Scotland?
No further questions now.
No further questions. At any time, please interrupt myself or Mr. Gordon or Mr. Leaven to indicate if you have that update during the day, Mr. Lopez. Okay.
Mr. Bray, if I could just come in.
Of course.
Mr. Grosvenor is trying very hard to get into the meeting. I think he possibly had the wrong link. So he's kind of there. He has been sent the right link. So again, I'm sorry for the delay, but I think we should perhaps wait just for a couple of minutes to see if he can join us, because we're just about to talk about what we want to talk about.
Yes, I think that is appropriate. Would be prejudicing their interest if we didn't allow that. So, Mr. Reid, maybe you can suggest a time. Is it a 5-minute pause at the moment?
Yeah, I think it'd be appropriate to maybe just break for 5 minutes. I think we got through that of the agenda a bit quicker than I'd anticipated. So I think we can wait the 5 minutes to see if we can get Mr. Grosvenor on the Teams call. So if everybody can just bear with us while we do that, I'd really appreciate it. Mr. Grosvenor, can I check you can hear me?
Yes, I can. Can you hear and see me?
I can hear and see you loud and clear now.
Okay.
We paused the session to wait till you got on board. We had to commence with part of the initial part of the noise session, but we obviously want to hear your evidence today. So we will bring you in at the appropriate time. Mr. Bray is leading this section, so he'll be the reporter who will bring you in to ask you about your evidence.
Okay.
Mr. Bray,
I think at the moment, I don't think everybody else has come back.
yeah. So we're on a pause at the moment. So if you just give us a couple of moments, then everybody else will hopefully reappear and we will commence. Okay, hopefully everybody else can hear me. We now have Mr. Grosvenor on the Teams call, so if everybody else is available and ready to recommence, I will wait till I see everybody before we start. Okay, I think that's everybody back. As I say, Mr. Grosvenor is with us, although he's disappeared off my screen. Can you still hear me, Mr. Grosvenor? I think we may have lost them. Right. Right, bear with us while I just double check. He was with us and I was speaking to him. Okay, we seem to Mr. Grosvenor off the call again. Mr. Braid, do you want to progress with any matters, or would you prefer to wait to see if we can reconnect with Mr. Grosvenor?
It might be useful to hear from Mr. MacLeod. Mr. MacLeod, at the start of the meeting, highlighted he had an approach or something to say about the late submission from Safe Straighten for Scotland. So maybe if we hear that and then maybe come to a view how we deal with noise. Mr. MacLeod.
Thank you, sir. I'm very happy to do that, although it probably requires Mr. Grosvenor to hear what I was proposing as well, unfortunately.
Well, if that is the case, then I would suggest, Mr. Reid, that we could potentially try and do item 5. I'm really reluctant to press ahead and have a discussion without Safe Straighten for Scotland. That it's the one area they're here to discuss today. And whilst it may be an inconvenience for others, it might be useful to try and make some progress throughout the agenda and return. I think that's fair in the circumstances of a virtual hearing where things sometimes go wrong. So I'd rather not proceed with the discussion, however long or short it may be, on noise at the moment, until we try our hardest to get them on.
Okay, thank you for that. Our party's happy to do that, to progress with other matters. The noise witnesses, are they still available for a bit longer this morning? Seeing. That's very reassuring. So item 5. It's obviously pretty big mess. 2 seconds. Item 5 looks at the section 36 conditions. We've already considered. Oh, Mr. Callan, you have your hand up.
Yeah, sorry, sir. It was just to say that your voice was breaking up again. Just.
Okay, I will try and move myself. I'll move myself closer to the microphone, and hopefully that will help. Item 5, section 36 conditions. As I said, we have already decided to leave conditions 5 and 6 on aviation matters to after the aviation inquiry hearing. I note that all parties have come to agreement on conditions 1, 2, 3 and 4. I'm just looking for nods that that's the case, that there's no dispute over those matters. There was just one small matter that we would just like just a wee bit of clarification on. The Carrick application is for a period of up to 40 years, which is quite sort of a long period and a bit longer than we would usually see. But we just clarify, with that lifetime, is that for all of the infrastructure within the Carrick development for that 40-year period?
Yes, sir, it is.
So it covers everything that would be on site? Yep.
It does.
Okay. I don't think we've got any further questions on any of the Section 36 conditions. So if parties are happy with that, we can move on to the conditions in relation to deemed planning permission. I'm seeing no hands up. Okay, we'll just work through these in numerical order. And if anybody has any questions or any issues, then please put your hand up. I'm now seeing that Mr. Grosvenor may be in the lobby. So I'm just going to pause here because this may be an opportunity before we move on to the deemed planning conditions. Mr. Grosvenor, can you hear us? Mr. Grosvenor, can you hear us and see us? I'm getting no response, Mr. Grosvenor. Mr. Grosvenor, can you see and hear us? We can hear and see you.
Can you hear me, Mr. Grosvenor?
Sorry, I'm having real difficulty. The connection keeps breaking up for some reason.
Can you hear me now, Mr. Grosvenor?
Yes, I can now, yeah.
And can you see everybody as well?
I can see yourselves, Mr. Bray, Carrick applicant, and
it may be helpful. It may be helpful if your connection is breaking up, that you switch your camera off. Sometimes that helps with the connection. As long as we can clearly hear you, then that would be fine. We've now reached a point of the agenda where we're looking at noise, and as we had a brief conversation before you were cut off, Mr. Bray is leading that section. So I will hand over back to Mr. Bray to take us through that particular section. Mr. Bray.
Thank you, Mr. Reid. In terms of a recap, in terms of the item discussion that you missed, Mr. Grosvenor, is that we reached a point that the council has indicated that it's in agreement with the revised conditions that have been operational noise condition 37 for the 3 applicants. If you do have access to the core documents, it might be useful to look at CD 1535. Mr. Lopez.
So it's just to say at this point we haven't agreed the Carrick condition. I'm still waiting to hear back from the council and their consultants on that.
Thank you for that clarification, Mr. Lopez. So the document CD 1535, which deals with Craiginmoddie, is replicated by Carrick and Knockcronal. It provides a useful comparison in section 2 of the document from page 6 onwards. So that condition is agreed for 2 and may be agreed for a 3rd application. So that's as far as we got in terms of finding out a current position with regard to the operational noise condition that's been put forward by the applicants. We were just about to move on to your position from Save Straight for Scotland. I was going to indicate that to all the parties to recall that you had submitted a document CD 1717, which was conditions of consent, and amongst other things, suggested a condition to protect those camping, and suggesting that amplitude modulation be treated as it was in the Denbrook Farm appeal. You've also submitted some changes to a previous version of the applicant's conditions this morning, and I believe that's been given a reference 1734, and that's just recently been submitted. Now, what I was supposed to do is ask you to explain, because we've not had a time to look at those. It would be useful if you explained the changes that you're proposing, and then it may well be that some of the participants have got a view or a view how we consider your suggestions today. But if I can invite you to talk us through the document that you sent in this morning with regard to changes. I hope we got all of that.
Yeah, no. Basically, I mean that document obviously is all the changes are in red. I did pick up on the change or the agreement from the initial final agreed version, which was dated. Oh, that's version 7, which was dated the 3rd of the 3rd, 2023, this year. And I did pick up on the fact that and we have looked at the latest submissions by all three applicants, which effectively remove the amplitude modulation condition. Our position remains the same. We're not happy with that, and our position is that as it literally is as this new document's 1737. That's the key change in there. And all that does is go back to our CD 1717. Obviously, there was, as discussed at the inquiry, a wish list, but we still want to see the amplitude modulation condition, the Denbrook condition, and again, we've put that in there. But there are some minor changes to the text within the document, which again, I can run through with you, but they're all in red. They're just nuances. And the first one is the definition of a dwelling at any dwelling noise, and we prefer noise sensitive receptors. Reference CD 1216, which is the South Ayrshire position. So that's the first one.
Well,
then we go on.
If I could just ask you to pause there just now, because you've explained quite clearly, I think, that those changes in red are your current position. I just want to bring in the other parties with regard to having had the time to have sight of these. It might not be fair in all the parties to have a detailed discussion until I ask them whether or not they're willing to do so. I've not read them this morning, and I think, Mr. MacLeod, you had a suggestion that you were going to put forward.
I did, sir. Thank you. I think we appreciate the fact that the conditions have been, or the last version of the conditions from the applicants has come relatively late. We appreciate that Save Straight Scotland will not have had a great deal of time to respond to it. And I think we understand why this submission has now been made. It only came to us 5 minutes before the hearing started. So as I've indicated already, we haven't had a chance to look at it properly or to obviously discuss it with our noise consultants. I personally have no difficulty with Mr. Grosvenor talking you through it today, sir, and explaining to you anything that he wants you to take from it. It does appear that some of the comments that are made in it arise from the most recent submission, the written submission that Save Straight for Scotland made. And we obviously have a written submissions procedure ongoing at the moment where the applicants have 3 weeks to respond to what has come in from Save Straight for Scotland. And my suggestion was that as part of our response, we simply addressed the points that are being made in this new document, CD 17.34. So whilst you have the benefit of hearing from Mr. Grosvenor today and him talking you through it, the applicant, or certainly our position, would be set out in writing as part of that written submissions exchange.
Okay, thank you for that, Mr. McLeod. You referred to the further written submissions from Save Straighten for Scotland. That's for others. That's CD 1722 through to 1733. I think all of the submissions that have been made in relation to that further written submission that just recently came in. The other applicants, are you content with Mr. McLeod's proposal?
Yes, in principle, I think that's very sensible. It's lengthy, that there are technical matters that need to be addressed. All I would ask is that we are given 21 days from today. And the reason for that, I think you recall, was that Mr. Mackay is busy sunning himself. I think he mentioned that on the call. So to give us time and to allow Mr. Mackay to deal with the technical side, I'd ask for 21 days from today.
And from the council's point of view, do you have any problem with having a further opportunity, albeit you've indicated that 2 out of 3 are agreed?
No, we don't have any issue with that. And also just to provide you with an update, the council and the consultancy have come back to me, and they've also agreed the Carrick condition as well.
Okay, thank you for that update, Mr. Lopez. Proposal that Mr. McLeod put forward seems reasonable. I think it would be useful to hear from Mr. Grosvenor today to talk us through the key matters in that document, given the efforts he's gone to connect today. And at the end of that, if I've got any questions, I'll ask them. And beyond that, we'll do or we'll amend existing further written procedure to accommodate, and hopefully we will be able to accommodate the 21 days. Mr. McLeod.
And it was just on that 21-day point, sir. I'm just wondering, would it be sensible for the applicant's response to be comprehensive? In other words, the submission that we're due to give you probably in about 2 weeks, we just extend that out to 3 weeks from today, so that you've got everything in one document rather than dribs and drabs.
Yeah, well, that's
sounds sensible.
I suppose meant by amending the existing procedures so that it ties up. So, Mr. Grosvenor, does that seem reasonable to you that we talk through, or at least you talk through the changes in your document 1734 as your up-to-date position, and then we allow a further opportunity for written procedures from the applicants and the council if they wish in response? At least then your comments have been considered carefully by everyone. Mr. Grosvenor.
Yeah, I'm happy with that. Again, I lost connection during that course of the discussion. So for some reason, the link here is pretty.
Mr. Grosvenor, have you lost connection again?
Sorry, I'm still here.
Just to summarise, then, if you want to take us through the document and highlight the changes, that's fine. And then what we've agreed, I think, is that it would be fair to all parties if we then amend existing further written procedures to allow parties to respond to your late submission. So over to you, Mr. Grosvenor, if you want to highlight any key matters.
Yeah, well, on page 1, as I said before, we're really concerned, although we go back through this in detail further through the document, but the first comment, conditions can only be a contingency in the event of the applications are approved. The reporter should request that the background noise tables are completely reassessed due to the ongoing non-compliance of Hadyard Hill noise levels. And of course, we submitted a document on that, which was referenced the assessment of the TNEI position. And that was CD 1723. And that's a report that requires further information on the following matters. Now, CD 1723, I believe, was submitted towards the end of last week, the 16th of the 6th. And that's partly the reason why we've been late in submitting these. But of course, the other documents submitted by the applicants, the last 3 revised conditions, we only got those again last Friday. Mr. Hewson's not available, and we have had a Skype call with him yesterday morning, whereby we went through the points, and that led on to this our revised condition 37. But as I go back, if we're talking about the change in wording on page 1 for any dwellings, at any dwellings to include noise sensitive receptors, again, that was put forward by Mr. Hewson in his evidence, both in his inquiry statement, which I believe is CD 1705, and also during the hearing. Then we want to add in a caveat on at A, which is in that original document, and also to include an independent acoustic consultant commissioned employed by the complainant on their request. We only see the local authority involved in noise complaints and the submission of data, and we cover that in that section. Then if you're looking at B, there should be no first commissioning of the developer until the wind farm operator receives an approval of planning authority, a list of proposed independent consultants. And we're asking there that the planning authority approve list of independent consultants and any subsequent amendments must be available on request within 7 days of such request to interested parties. I think that's important for openness and transparency. I don't see that there should be a problem with that amendment on B. C, again, we want to bring in that in accordance with the procedures described in the attached guidance note and the procedures described in DEFRA NAN R227, measurements to assess compliance with noise limits shall be undertaken in accordance with the approved assessment protocol unless the planning authority agrees in writing to a variation. All noise and operation data used in the complainant's investigation is to be made to the complainants and an independent acoustic consultant commissioned and employed by a complainant at their request at no cost. Again, that was brought forward in the hearing session. D, where dwelling to which a complaint is related is not listed in the tables attached to these conditions. The assessment protocol shall include noise limits to be adopted at the complainant's dwelling for compliance testing purposes. And then we talk about and we're going back to the details of levels which are selected from tables 1 and 2. We have a major issue with tables 1 and 2. The noise limits, if not in those in tables 1 and 2, shall be assessed using on-off testing in accordance with the IOGP. Note, there's a note in red, the noise limits in tables 1 and 2 are no longer considered to be valid and sound, and now that's inadmissible. Reference CD 1723, which is the document I referred to, and that comes out of the FOI and also Mr. Les Hewson's professional and highly qualified assessment of those documents. Then there is a change in regarding table 3, and again we're suggesting that the sentence paragraph, in the event that the consent of the complainants for access to the property to undertake a compliance assessment is withheld, the assessment protocol should be set out details of the proposed alternative representative measurement position. We wish to insert in red, a compliance assessment is required at the complainant's property. A compliance assessment need only be completed if access to the property is allowed by the complainant. I mean, that in fact protects the applicant. We do not want to see a proxy for assessment whereby we've got complaints at a specific property. ETSU and the guidance that we're aware of specifically deals with complaints at a location rather than somewhere else. And again, that may be a suitable location, it may be not. E, we wish to strike that out completely. That's underlined, that's got a line through. F remains the same. G remains the same, but note for the purposes of condition, a dwelling is a noise sensitive receptor. And again, we refer back to CD 05. Then CD 1717, we then give again, that's come from Mr. Hewson's suggestion for our conditions. So I won't go back into that because that's already there in that document that we've submitted, CD 1717. And then we talk about the limits for outside campsite areas. Again, that's there, that's in our CD 17.17. Then we go into given concerns over background noise measurements, table 1 and 2, need new background noise measurements. And of course, we see there, and this is the old document, we know that the new tables are being brought forward. We don't accept those tables. The tables that are in each of the applicants' new proposed conditions, we don't accept those limits as being valid and sound due to, as we've said before, the issues with the non-compliance of the Hadyard Hill developments at the moment. I mean, that needs to be addressed. You know, I mean, and I think it's good to have an opportunity for the applicants to respond because we have raised a significant issue here. And we're not seeking to disrupt the inquiry or cause additional difficulties to the inquiry, but it's important that with these developments that the local residents can have full confidence in the noise conditions that are set. Then we go back to amplitude modulation. I don't need to go too much into that because that's already there. Then note 1, that remains the same on page 6. Note 2, data analysis, that remains the same. And then note 4 is the one where we're talking about the AM penalty. And we've said before, the original condition did have an AM penalty. It referred to the IOA methodology. As Mr. Hewson said in his evidence, he wasn't happy with that. And so we're then proposing that the Denbrook condition comes through. Then we have the penalty chart there, and of course our argument is that the IOA AM condition is not tested. So we're also talking about replacing note 4 with impulsiveness. And also referencing BS 4142. And again, no doubt there'll be technical discussions on that. And then page 9, that just sets out the summary for the Denbrook condition and the Denbrook condition 20, which was brought forward from the actual our submission in Mr. Hewson's evidence at CD 05. And then noise emissions at the complainant measurements shall measure not further than 35 meters from any relevant building and not closer than 3.3 meters of any reflective building or surface or within 1.2 meters on the ground as stated in the noise hearing section So again, I don't want to go too much on that, but then we have the new submissions, CD 35, CD 37, 1535, 1537, and so that's the position on that. And then there's calculations on rating levels, and we refer back to BS 4142. Should not be restricted to the 2 minutes and gather continuous samples. Now, I think there is some changes on that where we're looking at longer periods, but again, we'd want further information back on that. And Mr. Hooson would respond to that as well in due course. And that's the summary of it. So there's quite a bit to unpick in there, but we haven't changed our position fundamentally. It is as stated in the hearing session. It is as stated in our conditions 1717, and it is as stated in Mr. Hooson's evidence at CD 1705. So that's our position, and you know, we would welcome feedback from that, but that's where we are today. So I don't really want to say any more than that at this stage, if that's okay.
Well, thank you for that. For leading us through that. I think that's been very useful for me anyway, and hopefully for others. The suggestion was to incorporate responses from the applicants and their parties into the existing further written submissions. I would support that. I don't think there's any real need to go into a discussion today because you've just seen it. If we allow time for all the applicants to consider it, I think that would be the best approach. Now that you've heard the context that Mr. Grosvenor has set out in his oral evidence there, we'll in doing that, we would write out and clarify exactly what we're looking for in the timescales and amend the existing further written submissions procedure. I would highlight, though, and it relates to the point that Mr. Grosvenor said about responding. We do have to draw these matters to a close at some point, and it's likely that the end of the further written submissions will be the end of submissions on noise. So with that, I would open it up to see if the applicants are supportive of what we're proposing.
Yes, very shortly.
Yes, we are as well, sir.
Yes, that's also agreed from the Knockcronal applicant's perspective.
And Mr. Grosvenor, you're quite content that we allow the applicants the opportunity to respond, and then we'll draw the noise conditions and discussion to a close in terms of written procedures. I think you've got mute on, Mr. Grosvenor.
Sorry, I dropped out again. But the only other point we'd like to just touch on, we don't intend to go into it too much, but there is a letter that's been submitted by Save Straighten with regarding the new agreements of community benefit, call it what you like, that's been arranged with the additional in regard to Taylor House, Taylor Cottage, and Taylor and Knockcronal. We are really concerned the implications of that agreement, and I'll just leave that there, because our big concern is whether those agreements remove any protection from those residents with regarding noise. We're not talking about landscape visual amenity. We're talking specifically about noise, and we would just ask the reporter to deal with that matter obviously separately. It does come into the noise condition levels, and we obviously Save Straighten, as representing Save Straighten Our remit is to act on behalf of the residents to protect their residential amenity, primarily with regards to noise, but also regarding visual and landscape, residential visual amenity as well. That's why we participated in the residential session on the 6th of June, I think it was. So we just draw that up, lay that on the table. We obviously realise that, you know, these private agreements between the applicants and the residents, but we do want to flag up the concerns that we would not want to see any watering down of their protection against wind turbine noise impacts. So we'll state that position quite clearly, and we'll leave that to the reporters to deal with in any matter, in any way you feel you need to. Thank you.
Okay, thank you very much for that, Mr. Gora. And because I think you might be choosing to sign off after the noise discussion, I think that was your intention. I will highlight just now that we plan at the end of the meeting to discuss further written submissions and closing submissions. It is our intention that there will likely be further written submissions on other matters, and there will certainly be that on the submissions that have been put in by Knockcronal on financial involvement. That's a new matter that parties have not had the opportunity to comment on. But because we've had so many oral procedures at the moment, we're leaving that until the oral procedures are complete. So there will be further written procedures to get parties' views on the implications of that and perhaps answer questions that we may have. We were going to mention that at the end of today's proceedings, but because you mentioned that just now, I would just flag that up. I'm not expecting the parties to open up a discussion just now on that matter. We can do that at the close of the hearing. Just to reassure you, Mr. Grosvenor, that we have got your correspondence and we were going to be dealing with the submission from Knockcronal by further written submissions.
Yeah, thank you.
Unless anyone is desperate to come in on anything that we've discussed there, I think we've got agreement on how we're going to deal with it. I think I can hand back to you, Mr. Reid, potentially to tell us that we're going to take a break.
Thank you, Mr. Bray. No break all the way through to lunchtime today. No, I think this is, can everybody hear me okay? I think this is probably an appropriate time to take a break. That will allow those witnesses who are no longer participating to depart. So we'd just like to thank those who have taken part so far and allow us to regroup and get back to looking at the deemed planning permission and conditions. So as I say, we've been going for about an hour and a half. So it's now 10:24. Let's say we take, is a 10-minute break long enough, or would people prefer 15 minutes to get a cup of tea and get themselves sorted? 10 minutes? I'm seeing not okay. So we'll get back at 10:35. Okay, thank you all. And thank you, Mr. Grosvenor, for attending this morning and your contribution.
Thank you.
Okay, I think everybody's back now. It's now 10:37, so if everybody's happy, we will commence with the hearing, looking at the deemed planning conditions. Checking if everybody's back. Yep, I think so. I think we're good to go. So we'll now move back to the agenda item looking at deemed planning permission. So my intention is just to take these through in numerical order, and where they're agreed, just if we can have confirmation from parties. Some may be agreed by parties, but we will still potentially have some questions for that. If one of the applicants is happy to answer, if it's in the same condition agreed through, if one applicant's happy to take the lead on the response, then that would be helpful. Okay, so if everybody's ready, we will look at conditions. So condition number 7, which was commencement of development, that now appears to be agreed between all parties. Is that correct? Yep. And we've no further questions on that. Condition number 8, which is final appearance and operation of the turbines. Again, there seems to be agreement between all parties on that condition, and we've no further questions to ask of that one. Okay. If there's any questions, obviously pop your hand up as we go through. Condition 9 on aviation lighting and condition 10 on aviation charting and safety management. These are both ones that will be carried over to the reconvened hearing session after the aviation inquiry. Everybody happy with that? Good. Condition 11, I think this was agreed between the parties initially. However, there was further correspondence came through looking at some sort of minor amendments to that, and I think the applicants were proposing some minor amendments. I just want to make sure that the council were happy with those additional minor amendments. So, somebody from the council.
Thank you, sir. So just back onto the conditions. So yeah, I don't think we do agree with these minor amendments. Well, in fact, just going through it, so I think there was a change on the first line from the to any. I think we can accept that, and then we go through, and then there's an addition of the relevant. I don't think that's, you know, a precise term. What are the relevant? So I think that should go back to all buildings, and then the or rather than and. I think it should be buildings and structures. So we're happy with the first change to any, but the other changes we consider are not specific. Well, the relevant isn't sufficiently precise. We don't feel that meets the test, and we do want to see details of all of those elements that have been identified prior to them being constructed on site.
Okay, thank you for that. Do one of the applicants want to take the lead in responding to the council's position? Mr. McLeod.
Thank you, sir. I have to say I'm a bit surprised, and I'm not sure whether there's a misunderstanding on the part of the council. The intention here is simply to avoid a situation where, for example, the substation, or maybe a better way to look at it, a water crossing couldn't be begun until the design of the substation building had been agreed. A substation building being perhaps a long way away from the relevant water crossing. The point was simply we acknowledge the fact that each of the individual components in Condition 11 will need to have its design approved. That is the planning harm which the condition tries to achieve. But we don't feel it's necessary to have a situation where every single element of the development needs to be approved before any element of the development can begin. And I thought that would be pretty non-controversial, to be honest with you.
Okay, would the council like to respond to that, please?
Yes, I do see the point that's being made. Maybe instead of the relevant corresponding buildings to make that clearer. I think we possibly had misunderstood the intention of the applicants on that.
Okay, so are you saying that you're happy with the any?
Yes, yeah.
And the or?
No, not necessarily. I do take the point that's being made here, but I think corresponding buildings and structures, I think, would be right.
The particular,
Mr. Hardy.
The particular building. It sounds as though, I mean, I agree with what was said initially on behalf of the applicants. The point is not to get tied down. Yes, we accept the need for control, but I wonder whether, if the council agrees with the premise, the particular building or structure. What we're trying to do is just to say each individual building. We don't want to get tied down to so that particular or the subject building or structure is what we're trying to get at. So it's just finding the word we can agree on for that purpose. So
I think what we're saying here is that the principle of what you're trying to achieve seems to be acceptable to the council. Correct, and it's just the choice of particular words. I think what we will probably do at the end of the session is ask for the applicants to update the conditions list with what we've discussed and decided today, and then seek further comments. So that will be something we'll pick up at the end, but that may help us to just address these more minor issues rather than spending all our time trying to select a specific word at this point in time. Are you happy enough, as long as we've agreed the general principle of it and we're getting down to a selection of a word, to do it in that manner?
Yes, absolutely. I mean, unless the council come back very quickly, I agree. That's a best use of time.
Okay, are all parties happy with that approach?
Yes.
Okay, right. Okay. Moving on to condition 12, which was relating to signage. I think all parties agreed to the wording of that condition now, and we've no further comments on that one. Moving on to condition 13, micro-siting. There are some issues that we would like to consider with regard to this particular condition, and I think Mr. Bray is going to take the lead on this particular condition. Mr. Bray, if you're with us.
Thank you, Mr. Reid. I think the council are in agreement with the conditions that are worded as drafted for Knockcronal and Carrick. So I just want to double check that is the case from the council's perspective.
That is correct.
Yeah, and SEPA have concerns with regard to micrositing with Carrick. I think they've confirmed that with their email submitted on Friday, the 16th of June. Their up-to-date position was CD 1540. Can I just get Carrick to confirm that you've seen that document from SEPA? Yeah. Okay. SEPA have in principle concerns over micrositing for certain turbines. I'm not sure we can take the discussion any further today because we've had the discussion in the specific hearing session. Unless the applicant wants to give us a response to what SEPA have said in their email of Friday. I think that came in around lunchtime. So I would give the opportunity for Carrick to respond, but I don't know if we can have a two-way discussion on it, if you like.
I think it would be difficult to have that discussion, as you say, in terms of the principal concerns, but in terms of the matter of the details, it probably would be helpful for us to clarify that maybe where the areas of disagreement are between ourselves and SEPA in terms of how things like deep heat and the scale issues on that condition are handled.
Yes, if you want to do that, that's fine.
Yeah, in terms of deep heat, I think SEPA obviously have concerns in that regard. What we're saying is that we think that there would be sufficient control within the soil and peat management plan, which would be part of the construction environmental management plan under condition 15, which is proposed. And the oversight and implementation of that in respect of limitations on deep peat and the volumes of peat would have appropriate oversight by the environmental clerk of works, which would be covered under condition 16. So we'd be satisfied that that would actually be the appropriate means to monitor and control that. In terms of the scale, I think SEPA have got concerns about our reference to the use of the 1 to 10,000 scale. We just want to draw to the reporter's attention that within Chapter 6 of the EIA report, that's hydrology, hydrogeology, geology and soils, that's within the assessment methodology that we've used within the EIA report of 1 to 10,000 is specifically mentioned, which is why it's entered into the condition as the appropriate means of capturing what our assessment was. And indeed, within our EIA report figure 6.7 hydrology overview, that is specified within the legend on that figure is 1 to 10,000. We think the specification of the 10,000 metres gives clarity and precision on what watercourses actually have been assessed and therefore should be subject of ongoing monitoring and control, which I think takes us to the same end of SEPA we're seeking on the other developments in any case.
Well, just on that point, if that's the case, and why haven't the other applicants taken that view? I mean, it's a different view to the applicants. If other applicants have just gone with watercourses rather than reference to a scale of mapping. So perhaps it might be useful to get the other applicants' views on that particular matter in terms of the definition of watercourses. The other applicants appear to just be happy to mention watercourses. So if we could hear from the other applicants first.
Thanks, thank you, sir. I'm happy to go first on this one if that's helpful. I think we do just, as you say, refer to watercourses, albeit I know that there are some reference to there is reference to a figure in paragraph 2b, figure 3.1, which references the site layout and key environmental constraints. I've not looked at the scaling of that figure, but you are correct, sir. We've simply referenced watercourses in our condition.
Mr. Hardy.
Not sure there's much to add. Don't have a very strong view. We think watercourses is satisfactory. We've used that before.
Is it from Carrick's point of view? Is it a really important point that you would like to make sure is in the condition, or would you accept consistency across the three conditions?
I think given that it's based on our assessment within the EIA report, it would be appropriate to maintain the 1 to 10,000. And I think that consistency does provide SEPA and the council with the necessary certainty of what watercourses would be overseen.
Does the council have any view on that?
We haven't raised a particular point on this, but I mean, it would seem logical to just reference watercourses across all three.
Well, I think we can take that away and consider that, and if there is to be further written procedures, then we can potentially deal with it there. But with regard to item 3 on the Carrick condition, that's 3 in brackets. With regard to the micrositing of turbines 1, 2, 3, 7, and 13. Just to be clear, that condition doesn't in any way disallow the turbines to be constructed in their current position. You're not looking to move the turbines and using that to microsite them in a slightly different location. That item 3 allows you to construct the turbines in their current location. Is that your understanding?
Yeah, it could well be the case, depending upon what's found through the peat probing it.
But I think my question is that caveat allows you to construct the turbines and infrastructure in their current location. I know we discussed a number of matters in the peat hearing at length. Just want to be, as it was written, you're not proposing that there is some sort of caveat that the turbines are not constructed until they're microsited somewhere else. Yeah, because I think you made the point at the peat hearing is that it's Carrick's view is that the proposal as a whole is consentable, as is proposed, with the exclusion of turbine 10. I just wanted to make sure that that was the case, because there was some discussion around using micrositing to relocate the layout, but that item 3 doesn't seem to do that. Okay. Does anyone else want to come in on that particular point? It's a matter in relation to SEPA. Anything else from the applicant, from Carrick? No. Okay. We perhaps go to Craiginmoddie now. I think Craiginmoddie, you've submitted a conditions rider. It's called 1539. It would be useful, given it's coming reasonably late, just for you to take us through that, please. It's a CD 1539, I think.
I'm going to draw that up. The IT's being a little bit slow. So the principal difference here is in relation to the distance. So it's 100 meters as opposed to 50 meters. And I think the point there says in relation to really ground conditions, it's in relation to micro optimization of benefits. It's also the case that the EIAR was written on the basis of 100 meter micrositing. Given the size of the turbines, it's the standard practice for this applicant, and I have to say my experience, other applicants, to seek 100 meters. Given the size of the machines, we consider that to be a proportionate distance. As you will see from the suggested amendments, that there is, and that's in Roman 3, that should be approved in advance in writing by the environmental clerk of works appointed under condition 15, and then the hydrological clerk of works, which would be appointed under condition 23.
And you've answered my question there in terms of why there's a need for 100 meter micrositing. I suppose the question to the other applicants is your site so different that you're content with 50 meters? Is 50 meters your standard working procedures for the size of infrastructure that you're dealing with? Perhaps come to Carrick first.
Thanks. Yeah, within the methodology for the EIAR, 50 meters was the parameters that we've set for our Rochdale envelope for the purposes of assessment. So that's why it's 50 meters within our recommended condition.
And Knockcronal?
It's the same principle, sir. The EIAR was based on a 50 meter micrositing allowance, and accordingly that's what we've secured by way of condition.
And in your experience, and I know it's not in your evidence, is 100 meters unusual? It's either to Carrick or to Knockcronal.
Yeah, I'm aware of larger microsighting allowances, as Mr. Hardy's mentioned. As I say, our assessment was undertaken on the basis of a 50-metre methodology.
Carrick?
Yeah, the Carrick applicant has experience as well of a greater tolerance for microsighting, but it's site specific and it's dependent upon the assessment that's undertaken with the EIR.
From the council's point of view, you've heard the reasoning there in terms of the assessments that have been carried out. Does that change your view at all?
I think we still feel that 100 metres is excessive. We think it is fairly unusual to request a tolerance as high as that, and we're concerned that that sort of level of microsighting tolerance could result in slightly different impacts as that were assessed in things like the landscape and visual appraisals. So we are in principle thinking that, yeah, we feel 100 metres is excessive. We think 50 metres has become the standard in most cases, and we think that's the appropriate tolerance that should be applied in this case.
I mean, so if I could just perhaps come back on that, it's absolutely not the case that it's down to 50 metres. If anything, it's gone the other way. And certainly experience on other sites that I deal with is 200 metres sometimes. So 100 metres is absolutely standard for this size of turbine. But also the EIA point that's just been raised by Mr. Lopez doesn't apply in our case, because the 100 metres was assumed in the assessments in the EIAR. So I appreciate the other applicants assessed on a different basis, but that was built into the assessments that we've done. So we maintain 100 metres, and if there has to be a distinction between the sites, it's justified, we say. And I think the controls in relation to signing off from the clerks of work and the hydrological clerk of works deal with the genuine planning issue.
Mr. Lopez, are there any particular types of impacts that you think that are unforeseen or haven't been taken into account in terms of the applicant's assessments?
Well, we obviously have the council's obviously of the view that there are significant landscape and visual effects and unacceptable significant landscape and visual effects in relation to Craiginmoddie, and there is a potential for those to be altered in some way through a 100-metre microsighting allowance. We've also raised concerns about the private water supply point. I'm happy to discuss the amendments proposed by Mr. Hardy in relation to that.
Just before we come on to that, Mr. Hardy, if ministers were to consent in the proposal, would a 50-metre microsighting condition provide to be a particular problem?
The approach, as I said, is what the 100 metres is what is being sought. But if 50 metres was the considered view, then that would be worked with by my client. So not preferable, but not preferable. But it's very difficult to say at the moment. The whole point of microsighting, of course, is to take into account some conditions which you don't know until you're on site. But it is not likely to be a showstopper.
Mr. Cullen, you had your hand up.
Yes, I just wanted to supplement Mr. Lopez's comments that the recent ACNI decision, CD 008.025A, the decision notice there includes a 50-metre distance, and also within it's a Planning Scotland material conditions, which is or model conditions, sorry, CD 004.016, that also refers to a 50-metre distance.
Okay, thank you very much for that. Well, I don't think I can probe that any further. I've heard people's views on it, and we might just have to come to a conclusion on it. Mr. Lopez, you were going to come back on matters with regard to private water supply in relation to the light sighting condition.
Yes, so we note the change to that microsighting condition proposed by Craiginmoddie, and that's in limb 4. And I think it's specific in relation to wind turbine 2. I think what we would say firstly is our concerns in relation to wind turbine 1, 2, and 3. Obviously, this doesn't overcome from the council's perspective, our objections in relation to this application. But if we are to include this condition, our view should be include 1, 2, and 3. And also, I'm not fully clear why it would require the NCOW sign off specifically. I think it should be the hydrological clerk of works. That would be the party that would be qualified to comment on private water supply matters.
I think Mr. Hardy has indicated it's an and, so the NCOW would be an additional to the hydrological clerk of works, which doesn't have an acronym yet. So are you talking about under item 2B that the council are asking that no microsighting of wind turbines 1, 2, and 3?
Seconds.
Is that what you're saying there? Microsighting condition, Craiginmoddie 2B refers to 2 and 3 not going any closer to the abstraction.
Yes.
Would you like to add, is your suggestion that you'd like to add turbine 1?
So I think it's that B should be 1, 2, or 3, and then 4 should also mention 1, 2, or 3, I believe. E4. Oh, sorry. That's the revised D4 that was in the further submission, the conditions rider by Craiginmoddie.
Yeah, I've got that now.
Hey.
Do you want to respond to that, Mr. Hardy?
I'll respond, Mr. Bray, if that's okay. So on part B, I think we could accept that no microsighting of turbines 1, 2, or 3 closer to the abstraction. I think that's okay. But for part 4, it's only wind turbine 2 that's currently within the surface water catchment as we've defined it. So it's only turbine 2 that we're saying will microsite outside of the surface water catchment, and it would need to move about 40 or 45 meters from its current position to be located outside. But turbines 1 and 3 are already outside the surface water catchment.
Mr. Lopez, do you want to come back on that?
Yes, sorry, I think obviously these have been received fairly late. I think I possibly misread that or misunderstood the point there. Yes, I think we agree with the E part 4 is acceptable.
And that's in the conditions rider.
Conditions rider doc.
Yeah, that's 1538. I think I got that wrong actually in terms of the reference. Could you just give me the reference for that, Doctor? Because I don't seem to be finding it actually. Mr. Hardy, the CD reference for your rider?
That's the rider. I've got that just as the 19th of June 2023. I'll look for the reference number. I don't know whether Mr. Briggs, do you know whether?
No, I can't see it anywhere. Just got the 19th of June as well.
Yeah, good sir.
Well, we'll confirm with Keith.
Could we come back? We come back to you on that. So if you haven't got it, then we'll.
I think if someone has it, because someone has their hand up from Carrick.
Thank you, sir. No, we don't have the reference. I just wanted to point out that I don't think the document's been assigned a CD reference yet. So it was only uploaded to Objective Connect this morning, so it might not have one.
Yeah, that's our understanding as well.
Right, that'll be the.
I think that's I would confirm that's correct. It just came as an email this morning, and it doesn't have a CD as the last time I checked.
I think, Mr. Lopez, you've confirmed that the councillor are content with that email that's come in. Okay.
So, that's basically subject to under Lim B. It's wind turbines 1, 2, and 3.
Yeah.
With which we're happy, yeah.
Would that include? I think there's some infrastructure just beside turbine 1, the substation. So that would, I think, from the site visit, I recall that being mentioned. So I think your view was turbine 1 associated infrastructure close by, and 2 and 3. I don't want to add more into the condition, but I just want to clarify your position, Mr. Lopez.
Sorry, that's correct. It should have an addition. You should also reference associated infrastructure.
So we're happy with that in B. So no mark starting with wind turbines 1, 2, 3, and any associated or directly associated infrastructure.
I think I can move on from condition 13, unless any other party wants to raise anything. Okay, Mr. Reid.
Okay, thank you, Mr. Bray. Moving on to condition 14, which looks at borrow pits. Just a few points here to clarify. Just to check with the council, there's obviously been a revision to that to add some timescales in. And it's whether the council are agreeable to the 36-month period for the opening up of borrow pits by the Knockcronal and Craiginmoddie applicants. So, somebody from the council?
Apologies, I was trying to click on my mic. Council can confirm that 36-month time period is.
Okay, that's great. Thank you for that. Does the council have any other concerns with the wording of the Craiginmoddie condition as drafted?
Just double check. Sorry. No, we're okay with 36 months.
Okay, that's great. Turning to Carrick then. Carrick, just sort of explain a wee bit more of what the issue is with using the timescale of 36 months, given that it's been accepted by the other applicants.
Thank you, sir. Our position on the time limit in the condition is that it's not necessary, and that the condition as drafted already achieves the aims set out by NPF 4. I could perhaps take you to NPF 4, which is core document reference 6.1 on electronic page 93 of that document.
Okay.
See at the top of that page, there's a policy intent section, which says that it's to support the sustainable management of resources and minimise the impact of extraction of minerals on communities and the environment. So the overarching point we consider is about minimising the impact of extraction. Condition as set out already achieves that aim and delivers on the policy intent without the need for a specific time limit. The use of the borrow pits are inherently time limited by the requirement to restore them at the end of the construction phase. So we consider that policy intent is met and that also we're compliant with policy 33E Lim 1. We don't consider that a specific time limit covering that is necessary.
Okay, it might not be, you're saying it's not necessary. Is it problematic to have a 36-month time limit on the condition in terms of your proposed construction?
I think the difficulty is that, first of all, Carrick's construction programme is a bit longer than the other two applicants. It's about 22 to 24 months. And I suppose there are just a number of matters that may arise that cause problems for that. Maybe something has to pause, or I don't think there's certainty that 36 months would be sufficient.
Okay, do the council have any comments on that?
Yes, we do, sir. It's mainly in relation to the consent timescales. If the Carrick proposal has a 35-year consent, there is nothing to suggest that the construction period could go longer than 24 months, and would get to a number of turbines not being installed, and I think that negates raises concerns for the council, and that's why we are looking for a 36-month timeline condition and be consistent across all the proposals.
Okay, I think I've got enough information on that. I'll leave that one there. Moving on to another matter for Carrick, just for clarification, CPIM made some sort of further comments in terms of 14B, looking for CEPA to be consulted on the scheme. I'm just wanted to confirm that Carrick are willing to include that now, or
Yes, sir, we are. It was intended to be part of the conditions table that was before you on the 14th of June. It was just an error that it wasn't included, so we're quite happy to include that.
Okay, and are there any other matters from the CEPA comments that you wish to highlight or raise before me?
No, sir, we've addressed all CEPA's comments on condition 14.
Okay, thank you. Just bear with me a second. Okay, moving on to condition 15, that's the ecological clerk of works. I think all parties have agreed to the reworded condition for that. Just looking across for nods, I think that's the case. And I don't think we've got any further to add to that. Mr. Bray, you've got your hand up.
Thank you. It was actually to return back to the previous discussion on micrositing for Craiginmoddie. I now have the rider up in front of me, and just so I want to be clear from Craiginmoddie, the revised Craiginmoddie condition on micrositing item 4, where that relates to the construction of wind turbine 2. Just want to be clear, are you saying that the current siting of turbine 2 is unacceptable, therefore you wish to move it through that condition, or is that your position after hearing what's happened through the hearing, and this is in a sense addressing the matters that were raised as a consequence of the hearing to address the concerns of the council? Just so we're clear in terms of reporting the reason for that, Mr. Hart.
Yes, so position remains that we are confident in what we originally set out, and that's the evidence of Mr. Wainwright. However, we listened to what was said during the session, and we feel if the decision maker thought this was a reasonable course to take, would be accepting of it. So we're not agreeing that it is unacceptable. However, a different view could be taken, and if that view is taken, we think that this is an appropriate way of dealing with it.
Thanks for that clarification. And sorry, Mr. Reid, for taking me back, but I just wanted that clarification.
Thank you.
Thank you for that. The condition 16, which is the construction and environmental management plan, we've got some various questions in that. I don't know, Mr. Bray, whether seeing as you're still on, whether you'd want to kick off with the matters you wish to raise under this condition. Mr. Bray, I think you're on mute.
was. I think the first thing is just to make sure that the council are happy with that. And that's in relation to I think condition 38 in terms of private water supplies refers to tree management plan required under this condition, and whether the council had any further comment on that.
Sorry, was that in the main? Was that in the conditions rider document? Sorry, I'm just trying to navigate around, or was that in the main conditions document as well?
I think that's in the main conditions document.
It is.
Okay, down to condition 38. So. It's about the reference to the tree managed to. I think we are happy with that.
Yeah, okay. I don't know, Mr. Reid, do you want us to go on to talk about biodiversity enhancement?
No, I can pick that one up. Yeah.
Okay.
The applicants don't consider that there is any purpose or need, I think are the words that are used, to secure an additional biodiversity enhancement plan. Can the council just outline what matters it considers are not covered by the applicant's approach as it currently stands?
I think this point was discussed in some detail yesterday. I think we didn't feel from the documents that have been submitted that that is necessarily demonstrated full compliance with the requirements of NPF 4 policy 3. I don't think that the sort of tally between the impact mitigation and enhancement has been sort of clearly communicated, particularly in one single document. So we think there is justification for biodiversity plan. There may be an argument for that to be conditioned, in association with the habitat management plan, in line with the Canny decision, which is on condition, which is reference to condition 19. So we see some logic in that, but we still feel that there is requirement for a biodiversity plan of some sort to be secured through condition. And we also note there has been a request for some further information on this point from the reporters.
Okay, one of the applicants want to respond to that. Carrick.
Thanks, sir. Yeah, I'd agree with Mr. Lopez that it was discussed yesterday, and our understanding is that the reporters will be issuing a request for further written submissions to clarify all applicants to be able to direct you to information that's available within the EIAR and supporting information about the level of biodiversity enhancement. It does cut across a couple of documents, but we think that's appropriate and legitimate. And within the written submission response, we'll be able to demonstrate what overall biodiversity enhancements will be. And following the outcome of that, our position is that it would allow you to have necessary information to conclude an assessment under NPF 4 policy 3. And indeed, that should negate the need for a planning condition on that specific matter.
Okay, do any of the applicants want to add to that?
No, we agree.
Yeah, I think the same principle applies from Knockcronal's perspective in terms of biodiversity enhancement is secured by way of condition already, and specifically by virtue of condition 24, the habitat management plan, which does secure enhancement condition provisions on the face of the condition itself with respect to wetland modified bog. And also there is a requirement under that condition for the final approved habitat management plan to be in accordance with the outline management plan, which has already been submitted. That's CD 3.176, which details further biodiversity enhancement measures in respect of the Knockcronal project. So clearly biodiversity enhancement is part of our proposal and is compliant with national policy in that respect. The council, and we can come on to talk about decommissioning specifically, but one area of disagreement seems to be the need for biodiversity within a specific phase of development. so during the construction phase or during the decommissioning phase, and for an enhancement provision to be secured in the associated conditions. I can't see anything in national policy or a local planning policy which suggests that that's a requirement. The principle of biodiversity enhancement is secured by the Knockcronal project. But in any event, I understand you may well be seeking further written submissions on this matter, and we can comment further then.
Okay. Mr. Council, have anything else to add? Listen.
Just to say that obviously we haven't seen those further written submissions, so the absence of that, we still think the condition meets the tests. And obviously, you know, if those further written submissions are found to be acceptable and in compliance with NPF 4, then any enhancements that those set out would need to be secured by condition.
Okay. This one, other comments on that? I confirm with the council whether they're content with the separate condition on the CTMP, and do they also need to be listed in the CEMP, or is this duplication? I think this was a question that was raised by the applicants.
Yeah, I'm just having a look, sir. Yeah, I believe there is an element of duplication between the two, but they are very closely related to each other. And it's certainly been my experience in the past that the construction traffic management plan on occasion does form part of a CEMP condition.
But there's no concern about it being a sort of separate condition.
There is no concern by the council, just as long as it's captured.
Okay, does anybody else wish to add to that? No, okay. Construction noise, I think, is our next question. I don't know whether, Mr. Bray, you want to raise anything here in terms of noise.
Well, it's really just double check that the council are content. Which it seemed to be.
Is this still in relation to condition 16?
Yes, we're still in condition 16, just to check whether the applicants have included a separate condition on construction noise on this, and just to check whether whether the council consider that is sufficient. I think it's at you'll see it in the column, in the end column, towards the bottom of the website.
The council is to 6.
Okay, fine. Is there any other matters from Mr. Bray in terms of that condition?
I think with regard to Knockcronal, I think through further written submissions, although I don't have the reference, there was clarification on enhanced mitigation of turbine 1 and turbine 9 hard standing due to limited space between watercourses. And would that be something that should be captured under lim H, 1H for Knockcronal? My apologies, I don't have the CD reference number, but I had taken a note that through further written submissions, there was a need for a slightly different mitigation due to spaces between water courses for turbine 1 and turbine 9 hard standing. If anyone can recollect that from Knockcronal, that would be welcome. I'm just wondering if it should fit within lim H.
Thank you, sir. I suggest I check that point during the break and come back to you. It may well be that there's already provision within the condition which provides that comfort, albeit I do think it's a matter that should go away and double check if we can revisit that after the break.
I'll perhaps do my best to try and find your CD reference as well.
Thank you.
Okay, happy to come back to that matter. Moving on to condition 17, which is construction hours. The applicant's response, which is CD 015.038, included some revised wording set out for the condition for both Knockcronal and Craiginmoddie, and Carrick was to match Knockcronal. Just to check with the council that they're satisfied with the revised wording for both Knockcronal and Craiginmoddie.
Yes, we accept that, that revised wording.
Okay, just in terms of Craiginmoddie, let me just bring myself to the right point. Yeah, just check, do you consider that the wording of item 3 requires a definition of daylight hours? Just is that precise enough about timing? Craiginmoddie?
The only suggestion I've got is reference to sunset and sunrise, which are effectively the same thing, but it is possible to look at those and have an objective reference point.
Okay, do the council have any views on that?
We'd have no concerns with that.
Okay, that's great. Thanks for that clarification. Moving on to condition 18, which is the abnormal indivisible load traffic management plan. Carrick, hand is up. Is that in the previous? Yeah.
Yes, sorry, just on the construction hours condition, I just wanted to clarify that Carrick was not part of the rider to those changes, but subsequent to that, we do agree with the changes and would align with the other applicants.
Okay, that's very helpful. Thank you for that clarification. And moving on to condition 18, Mrs. Leven has some points of clarification on this condition.
Thank you, Mr. Reid. So that's the EIL traffic management plan, and obviously I've got no problem with the conditions not being entirely consistent if there's a reason for that, but there's just a couple of things I've wanted to flag up to get your views on. So does there need to be consistency between the 3 sets of conditions in relation to references to Consulting Transport Scotland and Police Scotland? They are referenced in the Carrick condition, which I think Craiginmoddie is going to copy, but not in Knockcronal. Is that something that should be consistent, or is it not a problem? Does the council want to respond first?
Yes, ma'am. Yeah, this would be for consistency across, and if that meant a more robust condition, we would be agreeable to that amendment.
Okay, and the applicants, is there any concern with that? No. Okay.
I don't think there's any concern from our perspective if we're inconsistent there with regards to consultation. Certainly Police Scotland would be consulted in any event for those sorts of arrangements.
Okay, that's helpful. And on a similar sort of consistency point, is the council content that no trial run is required for the Knockcronal AIL route? There does seem to be one referenced in Carrick and Craiginmoddie proposals, but not in Knockcronal.
I think for consistency's purposes, yes, we prefer, but it's not something we brought up, nor had Ayrshire Roads Alliance. We're looking for a consistent approach across the conditions.
Okay, maybe the applicant could comment on why that wasn't included in their condition. Is there a particular reason for that?
I'm not of any. I don't think we have any particular concern with aligning with the other parties on this, albeit that is a matter I would want to double check. I obviously, in the absence of, albeit it's not secured by way of condition, it may well be that a trial run is required in any event by the roads authorities and Police Scotland, and the applicant would of course comply with that if that were the case. But I'm certainly happy to consider a change to that condition to secure a trial run and align with the other applicants, subject to checking that with the Knockcronal applicant and my instructed, who have been instructed by in that respect. I think both two parties, and I think we obviously the applicant's traffic witness may have some comments on that, given they have fed into the condition, and of course the Knockcronal applicant themselves as well.
Okay, I mean, if you're able to feed that back in during the course of today, that would be great, but we'll leave that.
I'm sure we can do that. Yeah,
thank you. And then the other issue was just to hear, we'd be interested to hear Craiginmoddie's views and the council on adding in a specific measure into this condition around the restoration of the new section of the AIL route from Daly over to the U25. I think, as I understand it, that was suggested at the transport hearing, and it does seem worthwhile. So we wondered what the details might be, and the wording of a condition, whether that's acceptable in principle or in detail. Would the applicant like to come forward on that first?
Yeah, I can provide a few points in response to that. So the track will need to remain in situ for the duration of the wind farm operation, and that's just in case of a blade failure or any component that needs to be replaced. We wouldn't want to construct the entirety of the new track again, but it would be kind of covered over and allowed to naturally reseed and revegetate to soften it up around the edges. That's the sort of thing that would happen in practice. Whether that could be included within a condition, we'd be happy to take a lead on that.
So during construction, it needs to remain in situ. I understand that, and then after construction, allow it to kind of what was the wording you used there?
Naturally revegetate and soften up around the edges, but the underlying structure would still be present. And if we needed to go in during the operational period of the wind farm with any new turbine components, we'd scrape back any vegetation that had taken hold on the top, reuse it, and then soften it up again.
Okay, I'm not sure whether that will respond to some of the concerns that have been raised, and whether that is a slightly different interpretation of what was given at the transport hearing, but perhaps the council could respond to whether that sounds reasonable from their perspective.
Apologies for the delay. Yes, I think the council would consider that acceptable. I think it's becoming reasonably standard practice to have access in place after construction has taken place, and that should there be an event where a blade needs to be replaced or a component, that access can be reopened and reused.
Okay, that's fine. Don't need anything more on that at the moment. That's fine. Do you want me to carry on to the next? I see the next one is also transport related, number 19. So that's the transport of materials, and I think Carrick's agreeable to including this as a standalone condition, but considers the term construction materials to be a bit vague. So just wanted to check with the council whether it could confirm whether it's now accepting of the revised wording.
Yes, ma'am. I'm just checking through it there. I think we should be okay. I was going to suggest that maybe the title of the condition may be reworded as well, or rather than transport of materials, it seems to be more. Condition 19 seems to be more in relation to wheel washing, wheel cleansing facilities.
Okay. I mean, there is a question about whether I suppose I should probably started with this, about whether there is a real need for this condition. If there are other powers and provisions that can deal with this, do we need this separately? Or in fact, if we do need it, does it just go into the CTMP condition? Do we need to have it as a separate? So I suppose there's a few issues around the sort of principle of the condition first that we should go back to.
Yeah, I do believe that the council will seek the wording of conditions as set before you, whether that's as a standalone condition or whether it's included with the CTMP, as long as it's captured. I think it's reasonably standard to make sure that the vehicle wheel cleansing facilities and sheeting is used, and it provides some level of enforceability for the council should there be a complaint of muck and debris on the road from vehicles, and whether there is any dust and debris coming off any vehicles if they weren't sheeted. It is primarily from an enforceability perspective for the council.
Okay, so it sounds like there is agreement that it's needed. Do the applicants have any concern being subsumed in the CTMP condition? Would that be better?
I think, Mum, that would be the view from Craiginmoddie, that can be subsumed within the CTMP condition, but that's it's just a matter of form, isn't it? The substance, I think, is agreed between the parties. It's just tidy. I don't think it requires a standalone condition.
Yeah, well, that will resolve the issue about the title, so we'll just put it into the CTMP. Okay, that's helpful. Any other questions on that? 19, no. So 20 relates to the CTMP itself. I can just skip. So presumably the council's happy with that as a standalone condition. Mr. Scott, do you have a question?
Yes, ma'am. It'd just be helpful for Carrick's perspective to clarify if the council are happy with the WIN-2 amendments on the Carrick condition in terms of loose and deleterious material. I think it may be subsumed into another condition.
I think they said they were, but I'll ask them to confirm that.
Yeah, yes, we are.
Thank you. Is that sufficient, Mr. Scott?
Yes.
Okay, so turning back to condition 20, a few questions there. So one question was just around the fact, in the face of any contravention of the TMP out with South Ayrshire, obviously that might relate to access to Carrick from Glentrool. Is there any issue around enforceability of the condition, or is the council happy that that the wording is sufficient as it is?
I believe the wording is sufficient. We have reviewed all the traffic and transport related conditions with Ayrshire Roads Alliance, and they've accepted the wording as laid before you.
Okay, that's helpful. And I just wanted to check with the council again that there's no need to add any specific items that were highlighted at the transport hearing. We did discuss a number of things such as speed limits, avoiding school peak times, measures to prevent convoys, those sorts of issues. I understand that the council was content that they didn't need to be identified specifically in the CTMP. Is that correct?
That is correct.
Okay. There's a few other issues about sort of consistency that I'll come to, but I just wondered, coming back to the issue that Mr. Hardy will be aware that we've discussed a couple of times, which is limiting the use of the access track between T2 and T3. Is that something that is being put forward as a proposal? Is a form of words suggested for a condition? And if so, would this be the place for it? Mr. Hardy?
Yes, we've looked at that. The answer is we are amenable to the deletion of the track between turbines 2 and 3. We've looked at the proposal for a condition, and obviously if that could be done, we would be happy with that. But we wondered whether or not that ought to be done through the Annex 1 description of development in the decision notice, in the same way as if a section 36 was being granted under exclusion of a turbine. So when you look at those sorts of applications, and there are some examples that we've seen, you see that done. So we could do that in closing submissions, where we could invite you as the reporters to recommend that consent be granted with the exclusion of that particular part of the track. So that's our sort of legal view. Principle is yes, we are going to exclude that bit of track between T2 and 3. Whether it's done by way of condition or it's done by exclusion maybe can form the subject of debate, but that's our resting point. We think it's probably better with an exclusion in the description of development.
Okay, that's helpful. So I think just to get the council's view on that, whether you would have any objections to that approach.
We agree with Mr. Hardy's suggestion of excluding it from the description.
Helps. I think as you say, Mr. Hardy, that can be highlighted. Just a couple of other consistency issues. If we look at Knockcronal, item H of Knockcronal's condition, it refers to a Section 96 agreement. And I think we've had a discussion briefly this morning and previously that we wouldn't necessarily need to refer to the Section 96 in the condition itself. Are parties agreed with that? Is the council happy to amend that?
Sure. Yeah, we're happy to amend that.
Okay. And Knockcronal condition element A refers to the establishment of a construction liaison committee, while Carrick and Craiginmoddie refer to the identification of a nominated person for road safety issues. Is there any reason for the difference there? Is it a problem? Does the council have a view on that? So it's just slightly different approaches to liaison. Is the council content with them as they are set out?
Yeah, we're content with the use of a community liaison group.
What was that? Sorry, I missed the first part of your answer.
We're content with the use of a community liaison group to cover this area.
But are you content that it's not the same in all three, or are you suggesting that it should be the same in all three?
It should be the same in all three. Again, like a broken record, the council looks for consistency across their conditions.
Okay, so if I could ask the applicants just to comment on those differences. Mr. Gibson, you've got your hand up.
Yes, I think we've secured that, as you say, ma'am, by way of the CTMP condition. I think the genesis of any disconnect between conditions might be that we did have a single construction traffic management plan condition, which I think the council's preference was for a separate CTMP condition, and so there'd be one for abnormal indivisible loads specifically, and then another one for construction traffic management plans. Our construction liaison committee commitment is in the CTMP condition, albeit I do think Carrick and Craiginmoddie have an equivalent under the AIL traffic management plan condition. So across all three projects, there certainly is a commitment to a construction liaison committee.
Okay, would the other applicants like to comment? Mr. Hardy?
It's a matter again of form really rather than substance. We're content with the way we've set it up. We're not going to down a ditch if somebody wants to put it elsewhere. I think it's about wording rather than principle.
So are you saying it is in the AIL condition?
Yes.
Let me just go back to check. Right, okay. And Carrick, would you like to comment?
Yeah, just to reiterate that point, I believe it's lim H under our condition 18 for the abnormal indivisible load in terms of the committee. So we're happy to maintain consistency as seemed appropriate.
Okay. And presumably the focus of that committee is on the EIL then. You're not concerned, sorry, the council is not concerned about it not having a slightly wider construction traffic unit.
I believe the council would prefer to be covered under the construction traffic management plan because that encapsulates more than just the normal indivisible loads.
Well, I think if that's, as I say, a matter of preference. If that's the way the council wants to do that, then we would agree with that to see consistency.
Next point, just a moment till I check the reference. Yeah, the next point again refers to Police Scotland. I think Police Scotland are referred to in the Carrick condition here. I think at the end of the condition, the last paragraph of it. Is that something that needs to be referred to in the others? Could the council comment on that?
Yes, we would be agree with that and would prefer that from, again, a consistency purpose, but also there would clearly be the requirement for Police Scotland to be involved anyway.
Do applicants have any concern about that?
Yeah, we're happy with that.
Yeah, there's nothing from Knockcronal on that. Yeah, that's fine.
Again, in Carrick, there's no reference in Carrick to Transport Scotland and signing off the CTMP. Is that because there's no trunk roads involved, or is there another reason? Is it just a difference in approach on that? Could they be? Mr. Scott?
Yeah, the condition was informed by the consultation responses from Transport Scotland and others, and it, as I understand it, wasn't explicitly requested by them for that purpose.
Okay.
It's appropriate.
Carry on, Mr. Scott.
Yeah, if it was considered appropriate, as with the Police Scotland, it's only where necessary, so we wouldn't have any great contention if it was necessary for Transport Scotland to be a consultee, but that would still be a matter within the control of the planning authority in any case, notwithstanding what's in the condition.
I think that's all my questions. We have discussed already the matter of the deposit of debris on the roads, and if we're bringing that into this policy, then that should solve the other question I had there. Any other questions or points to condition 20? Mr. Bray, you've got your hand up.
If we're finished on that condition, I was going to take Mr. Gibson back to a reference that I'd mentioned earlier on that we couldn't find. The reference is CD 1667, and it was Knockcronal's response to further submissions on hydrology, geology, etc. It's on electronic page 9, and it's paragraph 4.4, and it's with regard to turbine 1 and turbine 9, and it did indicate in that paragraph that additional mitigation measures were to be included within the construction environmental management plan. And that was my question. I know that it's mentioned in 13, condition 13, that there is a mention of turbines, these two turbines with regard to micrositing, but not the additional mitigation that seemed to be implied in that submission. Condition 13C deals with micrositing, i.e. no closer to water courses. But your submission in 1667 paragraph 4.4 suggests that there would be further mitigation required and detailed in the construction environmental management plan. So that's the reference, not necessarily looking for a response just now, but perhaps by the end of the day you could have a response on that. Okay, Mr. Reid.
Thank you, Mr. Bray. Moving on, actually, I think it's Mrs. Leven still has one final condition 21.
I think actually everyone's content with that, but I just want to make sure that the council is content with the revised wording on condition 21 on the access management plan.
Yes, I believe we are content.
Okay, any other comments on that one? No.
Okay, thank you. Moving on to condition 22, which was Western Access Route monitoring of Glenalla Farm private water supply. Only applies to one applicant. It's been agreed by the council, so I don't think there's any further questions or points anybody wishes to raise. Saying no. Moving on to condition 23, hydrological clerk of works. Mr. Bray, I don't know if you want to pick it up at this point.
I just, although it's been agreed, I just wondered whether the first element is actually required. It's superfluous.
Yes, sorry, is that for the council? Sorry to.
I didn't actually say who it was from, but we'll let you go, Mr. Lopez. Your view on whether one is actually required.
Yes, I think it's not required.
Applicants, I mean, this is not a massive point, but it's just in terms of honing down the conditions. Is item 1 really required? I don't know if any one of the applicants wants to go first. The terms of appointment are set out in 3 and below, so.
Yes, exactly. We don't think it's necessary.
The other applicants, do they agree with Mr. Hardy?
Yeah, I agree with that. Clearly, if the environmental clerk of works happens to have the right skill set to also deal with any hydrological commitments, then they can do that. But yeah, it's not necessary to have that LIM 1 in the condition.
Okay, I think we're clear on that for condition 23. Want me to move on, Mr. Reid?
Yeah, I think the next several conditions are areas that you want to pick up some questions in, Mr. Bray. So if you're happy to continue, that's fine.
I was just wondering if people are content that we keep going. Just now, it's just 12 o'clock. Are you happy that we just keep going?
I'm okay.
Yeah.
I was going to suggest, Mr. Bray, whether we break for lunch at 12:30, given it's been a long morning, and then we come back at 1:30 rather than trying to push through to 1 o'clock. That would give parties a chance to break a bit earlier, if that suits.
Okay. So condition number 24, that's habitat management plan. There seems to be a general agreement from SEPA for the Carrick conditions. Is that Carrick's understanding?
Yeah, I think that's fair to say so.
And for all 3 applicants, then there is no commitment for a deer management plan as a part of any of the elements of this condition or elsewhere. I think they have been requested in submissions, and I just wanted to get your view on that. Was that an omission, or did you not agree with what some of the submissions potentially from Nature Scott that were made for a deer management plan? So any of the applicants?
I think from our side, we are happy to see that included. It can just be chucked into the wording, I think.
Yeah. Other applicants, would they be content with the requirement to produce a deer management plan?
Just got a big list. Yeah, we're happy to accept that.
Knockcronal, I think it has been mentioned with regard to all of the applications. Mr. Gibson.
I suspect we can align with the other projects on this, but if I could just confirm after the break on that point as well, please.
Yes, and if any of the other parties any further to raise, we can do that. For Carrick, I believe there's a request, if not a commitment, for a vole protection plan to be specified. Not saying it needs to be necessarily in here, and it may well be with regard to protected species, but I've got my note in here that I don't see the vole singled out for a protection plan anywhere, and I think it has been requested from Nature Scott, as I recall. So that's for Carrick. Maybe better under item condition 28, but was that a deliberate omission, or is that something that you were committed to?
It's something we're committed to, so just direct you to our schedule of commitments, which is Appendix 14.1 of the EIAR, which is CD 2161. For page 10, water vole is listed. There would be pre-construction surveys and a species protection plan for water vole.
And in that context, would you then be happy that a water vole is specifically mentioned in condition 28 then, given that condition 28 doesn't refer back to that schedule of commitments?
I think we'd be happy with cross-reference with the schedule of commitments or specification.
Okay, so a cross-reference to the schedule of commitments.
Yeah, I think that's consistent with other conditions that we've had. So,
okay, that answers my question there. That's all the questions I had on condition 24, even though we jumped on to condition 28. I don't know if any of the other parties want to raise. Mr. Gibson.
Thank you, sir. It was just going back to your question about the deer management plan. I've just gone back and checked the applicant's ecology chapter, which is chapter 8 of the EIAR, CD reference CD 3.11, and at electronic page 13, where we deal with consultation responses, there is note there that Nature Scott recommend that if deer are present on the site, there may be a need for a deer management plan or a draft deer management statement to be approved. I see the response there is that given the limited number of roe deer recording during surveys, indeed only 2 roe deer were recorded during the survey periods, and the suboptimal habitat on site for deer, a deer assessment was not considered proportionate for the site, and I believe that in turn a deer management plan has not been proposed by the Knockcronal applicant.
Thanks for that clarification, Mr. Gibson. Mr. McLeod.
Thank you, sir. Just one point, returning to condition 28. Ms. Moore was pointing out to me that if you look at the beginning of condition 28, there's a requirement for commencement of development for the species to be surveyed to be approved by the planning authority and in consultation with Nature Scott. So water vole should be covered within that process along with any other protected species. It was just to highlight that. There's no issue from our perspective, but it may not be necessary to specifically refer to them.
Thank you for that, Mr. McLeod. More matters to raise on condition 24. Happy to move on to condition 25, Habitat Management Group. You get to the right place. Craiginmoddie applicant has moved Nature Scott has a requirement. As far as Craiginmoddie is concerned, can the council indicate if they're in agreement with Craiginmoddie's latest response.
I confirm we are in agreement. I think the issue is what we're looking for is across the board, and this is what Nature Scott have requested on all three proposals. So that's why our position has been maintained of not all proposals have been agreed.
Yeah, okay. So Knockcronal and Carrick don't agree, and their position is set out in the schedule of conditions there. Is there a possibility to set out the arrangements for the management of the habitat management plan, just to be set out within that condition, that the arrangements for the management of the plan are to be articulated and agreed through the agreement of the plan, rather than having a separate condition? Or is there a particular need that a specific group is set up? And perhaps that is for the, so I know that one of the applicants has agreed to it, but the question to you is can the arrangements for implementation and monitoring of the plan simply be dealt with through the approval of the plan? That's to the council.
Yes, sir. We believe that it's required separately because it gives quite a role for the council to be involved, where I think the habitat management plan is quite specific and two different requirements. I think it'd be difficult to put them both together.
And how do you go about enforcing then the internal planning enforcement? How do you enforce the management of a group? If you can talk me through how that gets enforced.
Yeah, I mean, sorry, obviously I'm speaking on behalf of the council, but I'm not actually an employee of the council. We would be, I think certainly we'd be recommending liaison between all parties.
Knockcronal and Carrick, could you maybe explain further your position or your concerns with regard to the establishment of the groups?
From our perspective, sir, it's certainly not about not having ongoing liaison. It's simply that there's a mechanism elsewhere that secures the necessary arrangements, and this is effectively duplication having this condition. I'd point you in particular to condition 24, which deals with which is the habitat management plan condition, which specifies that the final HMP must be in accordance with the aims and objectives of the outline HMP, which is CD 3.176. And within that document, there is specific reference to setting up a steering group to monitor the aims and objectives of the habitat management plan on an ongoing basis. And therefore, this condition seems to duplicate that requirement.
Thank you, Mr. Gibson. Mr. Hardy?
The addition, I mean, the purpose of this is that the group, as you can see in Roman 1, is to oversee the preparation and delivery of that, but also to review and assess the results from ongoing monitoring. So there's an ability to make changes. So that's the additional reason for the group. In terms of enforcement, there is an enforcement in the sense that it's no development shall, I mean, it says prior to commencement, but no development shall take place until that's been established. So there is a legitimate enforcement to that extent.
It's essentially handing powers over to that a group.
There is a
Under item 3, and I suppose my enforcement question was around that, but perhaps can hear from Carrick first of all.
Thank you, sir. I would just like to echo what Mr. Gibson said. There is a mechanism in the Habitat Management Plan already, if you look at Limb 3, to review the plan and consider whether any amendments need to be made. In addition to that, on the enforcement point, we'd just like to raise that the Carrick applicant has had experience of this condition on other schemes, and the buy-in to a habitat management group has not been taken up, has not been very great, and it's been quite difficult to get these off the ground.
I think we'll need to consider everyone's view on that and come to a conclusion in light of the advice of Nature Scotland, but also everyone's submissions today. I'm happy to move forward from that condition to move on to the next condition. Everyone else is happy to move on. So we're on to condition 26, and that's water quality and fish monitoring plan. The council is in agreement. A question for Craiginmoddie. I think it is wise, number one, subject to the plan being prepared in consultation with Marine Science Scotland and the Ayrshire Rivers Trust, why that's specifically required. Is it the preparation of the plan? That's the matter there that you want to flag up?
I think it is.
And if that is the case, do any do Knockcronal or Carrick have any concerns about that? Item 1, which is in Craiginmoddie's proposed in the column Craiginmoddie.
Thanks, sir. Yeah, I think we're of the position that the condition as proposed for Carrick is appropriate. We don't think any amendment that Craiginmoddie would be seeking would be appropriate for our circumstances. We think within the EIAR, we've sufficiently captured what's to be assessed and addressed and identified to formulate the plan. We're comfortable we can do that, and then we would then undertake the consultation with the specified organisations.
Okay, and Knockcronal on item 1, that consultation in terms of preparation.
Yeah, I think I would just be echoing what the points were made by the Carrick applicant on this.
And back to Craiginmoddie then, is it a matter that is really important, or
no.
Is consistency
No.
the key matter here? If Craiginmoddie item 1 was not in the conditions, do the council have a concern?
I don't think we have a particular concern either way.
Okay, thanks for that. And item 2 in Craiginmoddie, does that not replicate what is in item 2? Or were you just restating that there?
I think it's just a restatement, so yeah, we don't need it.
Okay. I think we can move. I think there's one matter with regard to Knockcronal. I think that was the one proposal where freshwater pearl mussel surveys were requested. I think that was from the Ayrshire Rivers Trust from memory. And would that be something that should go into the condition in specifically, or do you think it generally addresses it through the commitment for fish and aquatic ecology species protection?
Thank you, sir. Yeah, I think we were treating that as having generally having been addressed, and accordingly there was no requirement for specific reference within the condition itself.
Thank you very much for that clarification. Are we all happy to talk about bats now? That's condition 27. Council, you've agreed that these conditions, and you don't have a problem, do you?
No, we don't have any issue with what's been presented.
There is a difference in wording across the conditions that might reflect the different types of responses you've had back and what was in your EAR. But the types of mitigation that were put forward by Nature Scott, feathering of the turbines and tailing turbines and such, are not specified in the condition. Is there a reason for not specifying the types of mitigation? And I think for Carrick, there was to be specific mitigation of turbines 2, 5, and 8. So my general question is, should the mitigation that is being required by Nature Scott not be set out in the conditions a bit more clearly? We don't need to go into the nuts and bolts. It's just that principle of setting out what the mitigation would be. Not so relevant for Knockcronal, but certainly for Carrick and Craiginmoddie, as they're called.
I believe any additional wording would be beneficial across the board.
I think that from our perspective, 2 provides sufficient comfort in that regard. So the BMP to include pre and post construction monitoring about populations and mitigation and proposals, including but not limited to reduction in turbine rotation speed while idling during the active bat season. So there is some detail there, and I think I don't personally see any reason why you would specify the technical detail now. It can all go into the BMP. There's that bit of detail in 2. So my preference would be to leave that as it is and to capture that in the BMP.
And is there any reason why the Carrick condition is slightly different there with regard to what has been put forward by Craiginmoddie?
You just repeat that.
Is there any reason why the condition is, for example, different to the Craiginmoddie one? You've not set out the buffer distance. You just looked for bat mitigation plan at quite a number of mitigations required from Nature Scott, and that it doesn't seem to pick them all up. Or is it the point that it'll all be captured by the bat mitigation plan?
Mostly on the latter, sir. So Carrick have prepared a bat mitigation plan. It's CD 2130. So that has been reviewed and I believe accepted within the consultation process. The reason for the condition being formulated as it is would allow any potential review for any particular species, as we've discussed under other conditions. Therefore, any changes in circumstances can then be caught properly within what is a suspensive condition here for those surveys to inform any update to the bat mitigation plan, and any mitigations that are specific to the site that are required would be caught in the plan. It would be premature to be able to capture those at this point in advance of that process being gone through. Sorry.
And would you have a problem with specific buffer distances being referenced in the condition? That's obviously a key part of the Nature Scott submissions. The 50-metre buffer.
Need to take that one away to check the consultation responses and just to verify against our draft plan that we've got for the bat mitigation, so we can seek clarification on that and come back to you on that, sir.
And on the matter of buffers, Craiginmoddie have got a 75-metre buffer, but you may or may not recall that Nature Scott came back to us, I think on the 18th of June, with regard to what the difference was between 75 and 50 metres. And it was because of the way it had been calculated. I think in Craiginmoddie, it was from the foot of the turbine out to the trees. And for the other applicants, it was from the swept path, the blade tip essentially to the trees being 50. So that's why there's a difference. And Nature Scott have clarified that. Nature Scott have clarified that the extent of the proposed standoff area should be a minimum of 50 metres, and that's from the swept blade area to the nearest surrounding forestry. So is there an issue with being consistent across all three, given that we've had Nature Scott's advice? That was received on the 14th of April. I don't have a CD reference to hand. And I suppose the question is to Craiginmoddie. One, did you understand the points I made? And two, is it acceptable to have a consistent 50 metre buffer for all three?
We're happy with consistent. Yeah, we're happy with the consistent approach.
I think it was clarified by Nature Scott.
It was.
We asked that.
Yes, exactly. Yeah.
The different way of measuring it. Absolutely.
Yes.
Okay.
Mr. Bray, I just think if it's helpful in that regard, I think we were proposing to update our limb 4 of the condition to specify that the buffer distance is from the blade leading edge, just to provide certainty around that 50 metre collision risk buffer zone. So if the other applicants are content to adopt the same wording, then we can capture that in the updated condition.
Thank you, Mr. Gibson. Yeah, we're happy with that.
And that makes it more precise, though. Thank you for that. Are we happy to move from bats? Is that your hand up, Mr. Scott?
It is. Just to come back on the point that I said, we'd come back to you on, we'd be happy to accept the 50 metre buffer, and that is consistent with the advice that we've had from Nature Scott on that matter.
Yeah. I'm glad I wasn't wrong with that. That's good. So we're on now to protected species survey, and we've talked about the vole. I just want to check the council happy with the wording.
Yes, by and large, we are content with the wording. One of the last tasks when we were looking through this particular condition was around the issue over a 3-month period before it started works. But that has now been included and should provide a robust condition.
So you're happy with those little amendments. For Carrick, there has been a mention of the implementation of post-construction osprey monitoring to be secured by planning condition. Does that need to be specified here? I think it only relates to your application. Scott, is that a deliberate omission? Do you agree with the proposals that came through the consultation with regard to osprey monitoring?
It's osprey monitoring is within our schedule of commitment, so anything that is committed to, we would have any contention with. It's on page 13 of appendix 14.1.
And we did discuss that you were content with the reference to that within that condition.
That's correct.
Okay. To item 29, a question for Craiginmoddie. Historic Environment Scotland asked for a planning condition regarding no increase in extent of a turbine visibility, as seen from the Bs 741. looking towards Kilkerran House and the garden and design landscape. That's from viewpoint 4 they referenced. So they were looking for more than likely a micrositing type condition, which meant that the turbines would not be more visible. Have you given that consideration, or do you consider it's not appropriate to cover by condition?
Yeah, we have given consideration to that. We don't think it's appropriate or workable or enforceable, actually. So for a number of reasons, we don't think it complies with the relevant tests.
I was just keen to get your views on that. We can move on to item 30. That's in terms of ecological mitigation. I believe the council and the applicants are in agreement now. Can I just double check that? I think there has been recent correspondence around from Knockcronal anyway, responding to the council's proposal. Can I just double check that that's the case as far as Knockcronal's concerned?
That's correct, sir. We've now amended our condition so it's consistent with the Carrick and Craiginmoddie condition, which the council has accepted.
I think that's CD 1538. I think that from memory. So
that's correct. Yeah, it was in our rider that we submitted on the 16th of June.
Unless anyone else wants to talk about archaeology, that's me done. I think unless you're not going to talk about item 31, Mrs. Levin.
I think at this point we're going to break. I think I'll give Mr. Bray a break from going through all these conditions. I think it's appropriate at this point. We've made quite good progress this morning, and I think we'll look on schedule to get through the rest of them this afternoon. So it's 12:23. I propose that we break for lunch now, and we return in an hour's time at 13:25. That suits everybody. Seeing nods from everybody, that's great. Thank you all very much. Good afternoon, everyone. I think looking at the screen, I think we're all back for this afternoon's session. I hope you had a nice lunch break. We finished the session on condition 30, but just before we move on to the conditions, can we just double check for Knockcronal, Mr. Gibson? I think there was a request about an update on the trial run as discussed under condition 18. I don't know whether that's been possible to update or whether that was answered during the session.
Thank you, sir. Yeah, I've just checked that and I can confirm that I think it's paragraph 1E of condition 18 of the Carrick and Craiginmoddie condition, which commits to a trial run of the route prior to AIL deliveries to be undertaken in conjunction with the roads authorities and Police Scotland. That the Knockcronal applicant is also content to secure that in the AL. And we'll make that update in the final condition schedule.
Okay, thank you for that. That's very helpful. Council happy with that? Yes. Seeing 2 nods, that'll do. Mr. Gibson, your hand's gone up.
Apologies, it was just to address one other point that Mr. Bray had raised this morning, which was with respect to securing additional mitigation measures for turbine 1 and turbine 9, which are both located within the 50-metre buffer zone from watercourses. The applicant did commit, as Mr. Bray advised earlier, in paragraph 4.4 of page 9 of its further written submission on hydrology, and that was CD 16.67, to additional mitigation measures in respect of these turbines. And those measures were restrictions on construction during wet periods, installation of sumps and pumps to capture and manage runoff away from watercourses, and a higher concentration of sediment control structures. And again, I would just like to confirm that we agree that those measures should be secured in the Kemp condition as we had committed to in the further written submission, and we'll make those updates in the final conditions schedule.
Okay, thank you for that. Were there any other updates from anybody else that was outstanding that they wanted to make at this point? I'm seeing no hands up, so that's fine. Okay, I think we'll move on through the conditions list. We finished that condition 30, which was the archaeological mitigation. Condition 31 is en route radar mitigation scheme, and that's one that will be held over for the aviation inquiry, which takes us on to condition 32, which is on shadow flicker. And Mr. Bray has some questions on this condition.
Yes, you might have thought it was all agreed, but my question is really to Carrick and Craiginmoddie why they don't accept the condition that is set out by Knockcronal. There's different wording, obviously. It's maybe not just a consistency matter, but if you could explain why you think your approach is more appropriate in comparison with what Knockcronal has put forward. So either Carrick or Craiginmoddie. Scott.
Thanks, Mr. Bray. I think it's consistency with the assessment that we've undertaken within the EIAR. We've also submitted further submissions on the shadow flicker in respect of the 10 rotor diameter. So given that those were the parameters for our assessment for shadow flicker, we think it's appropriate to have a condition that reflects that within any consent granted.
Mr. Hardy.
Just taking instructions, I think the principal difference was the restriction to 10 rotor diameters, and that's historical reasons. This is a condition which I've used over many years, but I think the instructions I've taken are that if that was felt, or inconsistency was felt to be more important, then we'd be happy with the Knockcronal wording.
I'm conscious that the 10 rotor diameter is used for assessment, but Knockcronal condition allows for if there were effects beyond that, which I think we've heard some evidence that there may be from time to time, that it would allow that to be investigated.
Yes.
So in light of that, Carrick, do you have anything further to add with regard to the 10 rotor diameter? Or do you understand the point I made about that maybe is for assessment, but for investigating complaints, it may be more appropriate to open it up a little bit wider? If I can hear from Carrick, and then I'll come to the council.
Thanks. Our assessment hasn't found that there'd be any effects whatsoever beyond the 10 rotor diameter. So just to reiterate the earlier point, that's why that's considered to be an appropriate caveat within the condition.
Okay, Mr. Cullen?
Yeah, just from the council's perspective, and hopefully maybe for a little bit of clarification, our understanding is that the Knockcronal doesn't have any shadow flicker issues as per come from their EIA. So the same restriction isn't required. But I think we'd be happy to accept that what is worded in the Knockcronal be added to Carrick and Craiginmoddie as well.
So the council would accept that. Carrick would accept either. It's just whether or not it's important to consider properties that may be outside the 10 rotor diameters, because there was some evidence that may occur. So I think we can just take that away and consider the parties' points, unless anyone wants to make a final point. Mr. Callan, you got your hand up again?
No, sorry, apologies. Take that.
Just I would say I didn't quite understand the point being made by the council, because if there wasn't any shadow flicker issues, then that would be a cause not to have the condition at all. That wouldn't be necessary. But your point, so was that, which I'd understood, was the difference between assessment and then derivation of complaints which might be outside the 10 rotor diameters. So I think we'll leave it with you, but we are happy that to cover the possibility of complaints outside the 10 rotors, that we would borrow or use the Knockcronal wording.
And is there a benefit of having a scheme in place, or and this is potentially for Carrick mainly, is a potential for a scheme, or is there benefit from having a scheme in place and approved, or is what's set out in Knockcronal's condition sufficient for a scheme? There's 2 points there. Is there a requirement for a scheme to be agreed if the Knockcronal condition delivers that?
Yeah, the advice we've had from our expert on the matter is that there would be a need for the scheme, which is why it's worded in that manner. Just wanted to clarify the last sentence on the condition. It wouldn't preclude the ability for the complainant to come forward out with the 10 rotor diameter distance. The 10 rotor diameter distance, as worded, would be for that assessment of the scheme. It doesn't in itself stop someone coming forward if effects were thought to be applicable to their property. Sets the handling procedure, but it doesn't stop someone coming forward.
Yeah, I think I'm pretty clear what the intent of the condition is. It's deal with complaints within 10 rotor diameter, and you can't get away from that in terms of the first sentence, I think.
So another suggestion would be to use the our example now, but just to take out reference to the 10 rotor diameters. So there should be no commencement of development until a scheme for the avoidance and mitigation of any shadow flicker experienced by residential and commercial properties which lawfully exist or for which lawful planning permission. So you could take that out. So the difference there would be, rather than just being pure complaint driven, which is iteration 1, you would have a scheme to be agreed. So we'd be relaxed about that as well. If you felt that a scheme to be approved was a better way of doing it, you can just remove the 10 rotor diameter restriction.
There seems to be a kind of middle ground there that Mr. Hardy's putting forward that sounds reasonable based on the discussion. I think Mr. Reid may at the end be asking for updates as far as the applicant's concerned. So that's maybe something for you to consider before we get our final hands on it towards the end of the process. Mr. Scott?
We'd be happy with the suggestion made by Mr. Hardy.
Okay, that seems to be the agreed position. Knockcronal, would you be concerned? I mean, that would mean that your condition is rewritten if it was across all three, but does that deliver what you were looking for through that condition?
Thank you, sir. Yeah, I mean, our position is that there is no significant effect from shadow flicker, albeit we accept that there are some residual concerns that have been expressed by the council and Safe Straighten, hence why we still proposed a condition on shadow flicker dealing with complaints. Notwithstanding that, I'm happy to take this point away and see whether there's any scope for the three projects to coalesce around the same wording.
Okay. Is there, since that further discussion might happen, is there a need to consider cumulative matters with regard to shadow flicker? Can a scheme sort out in which turbines are problematic? I mean, if in the scenario where L3 are consented, perhaps with reference to Knockcronal and Carrick, there may need to be some a process whereby the cumulative impact is worked through to determine which turbines are causing the problem. Is that something that you'd expect to be in a scheme, how to deal with complaints? Cumulative.
Just practically, the sun can't be behind two wind farms which are in different locations. So I think that puts it in a different category to say cumulative noise issues. So from our perspective, cumulative shadow flicker in these instances is not a physical likelihood.
Anyone else got something to say on that? Has the council got anything to say on that? Does the condition need to consider cumulative? In terms of the practicalities of investigating.
I don't think it's something we need to consider.
Okay. Mr. Scott?
Yeah, just I was going to confirm with the position of Mr. Hardy that it's satisfied, but the council already answered the questions. We're happy.
I'm happy to move on from shadow flicker onto compensatory planting. And I think we've had confirmation, I think, from the council in terms of condition 38 that you're happy with the amendment that was made. I think we discussed that earlier.
Yes.
Okay.
Agreed, yeah.
Mr. Reid?
Thank you, Mr. Brave. I think we're on condition 34, redundant turbines. I think that wording has been agreed, but I just want to check with all parties that there's no additional questions that they wish to raise in regards to that one. Seeing shakes of the head, so that's fine. The next one's financial guarantee. Again, all parties seem to. Mr. Lopez, your hand going up for a question.
Sorry, it was just I don't know if there's still an outstanding Glasgow Prestwick Airport comment that hasn't.
Yes, that's
not
one of the
green,
ones.
certainly.
Yes, that's one of the ones that we will be picking up. I think at the outset, there were the main aviation questions, or sorry, main aviation conditions, and then there were parts of some conditions that would still have to be looked at. So we will make sure that, although I did indicate the ones at the start, but anything that's to do with Glasgow Prestwick Airport, we will pick up when we reconvene, if that clarifies the matter.
Thank you. Thanks for clarifying that.
In terms of condition 35, financial guarantee, again, the wording seems to be agreed with all parties for that. Is that correct? Yep, we've no questions on that one. Moving on to condition 36, which is decommissioning, site restoration and aftercare. The applicants have provided an updated response, I think, for Knockcronal and Craiginmoddie in their submission, which is CD 015.038, which I think was the initial rider to the conditions that came in. And they proposed to match the condition wording as for Carrick. I don't know if the council have had a chance to look at that and what their position is now on that matter. I take it, a nod's a yes, right?
You said no,
Okay.
a nod was a yes.
Okay. Okay, so any other comments on that particular condition? No? Okay, again, there's part of that that relates to Glasgow Prestwick Airport, and we will pick that up as we go to the next session. Condition 37, operational noise, we dealt with that earlier on. So that takes us on to condition 38, which is private water supplies. And Mr. Bray, I think you've got some questions on this one as well.
Okay, all for Craiginmoddie, which is perhaps no surprise. First question, just to go out the road. There is a difference between the range of properties in item 2 and then 2A. Is there a reason there? Or is it because the properties are under 2 are the only properties shown in the figure within the EIAR? It's just that should they be the same properties, or is there a reason why there's a different list of properties?
I think they should be the same, just looking at that. Yeah, I can't see any reason why they would differ.
Okay, I'll flag that up there as a potential inconsistency. In terms of the council's comments, can I just double check that the council's outstanding comments are the bold ones at the bottom of the column 12, 6, 23?
That's correct, yes.
So in that respect, are you still happy with item 4 then? Item 4 is intrusive site investigation. I'm not convinced that you were all that happy with it before, so I just want to double check.
It's a valid point, Mr. Bray. It's probably one that I'll need to go and consult with the council and our other private water supply witness on, just to confirm our position on that. Apologies.
Certainly at the hearing, it was my recollection that was your position. So
yes,
that's what I would take your position to be. Okay. Just since I'm talking about that, bearing in mind the discussion at the hearing, Mr. Hardy, I know that the intrusive site investigation work is part of your EIA proposals. Do you think it's still it's required in light of the discussion we had at the hearing, or is it a condition that could be considered for omission? Or do you think it's important to the overall risk assessment process?
As you know from the hearing, that is considered to be validation and of what we have, what we've already stated. So if the view is taken that that wasn't required, then that could be omitted. But it's there on a precautionary basis.
And that confirms your position that
Yes.
we took at the hearing. So
At the hearing, yeah.
We'll perhaps turn to the 2 points that the council have a concern about with regard to the wording. We've got the applicant's response in terms of the right-hand column. I think it's under 14.6, 23, 1 and 2. And I think we did discuss it at the hearing, but I did ask at the hearing why it was important for the council to highlight their environmental health team rather than the local authority as a whole. Is there any change of position, or is that still your position, Mr. Lopez?
No, it's as we discussed at the hearings, it's consultation with environmental health as private water supply regulator as part of the drafting of the assessment. So it's not suggesting we're going to. Well, we may well consult with them after, or the planning team may well consult with environmental health as part of the sign off. That's not what this relates to. It's about engagement between the applicant and environmental health as part of the drafting of the assessment.
Mr. Hardy, you've set out your position there. Anything else to add?
Yes, no, I don't want to. We're not going to die in a ditch. Not over it. Our view is as was set out in the hearing. But I think it's one for you to take a view on.
Okay. And the second point was around advice. I think I remember some discussion at the hearing. I think potentially from yourself as well, Mr. Hardy, that last sentence under 2 take account of SEPA guidance. I think it was discussed that the condition would be as robust without reference to guidance there.
Yeah.
Because that was a point there was a bit of discussion on. I don't know if the council have got any particular view about the mission of any reference to guidance.
I think we've suggested adding it all in lieu of SEPA guidance, suggesting all relevant guidance, but I don't think we've got a particular issue with taking out any reference to specific guidance or any guidance.
Happy with all relevant guidance, Mr. Hardy, or just prefer not to?
Yeah. These are very fine points, aren't they? Yes, is the answer. All relevant guidance.
I think that's all the matters that I wanted to cover in that condition. Mr. Reid.
Okay, thank you, Mr. Bray. Moving on to condition 39, which is the planning monitoring officer. I think the council have requested that to be on all 3 applications, and I think the applicants have indicated that that this would duplicate the environmental clerk of works role. The applicants have indicated about precedents being referred to. So if they could if somebody would one of the applicants would like to kind of just expand on that a bit more, why they don't think it's considered appropriate for the planning monitoring officer as well. Anybody like to take the lead on that one? Mr. Gibson.
Yeah, thank you, sir. Yeah, I think as you touched upon, our position on this is that there is already an environmental clerk of works condition, which requires the appointment of an environmental clerk of works, which in itself requires the approval of the South Ayrshire Council as to who is appointed and who will be responsible for undertaking the role of the environmental clerk of works. And then in terms of the terms of reference of the appointed clerk, they are responsible for monitoring the ecological commitments, and there is a requirement to submit monthly reports to South Ayrshire Council. So to the extent that we're talking about potential infringements of ecological commitments, that's covered by the environmental clerk of works condition, and a similar principle applies with respect to the hydrological clerk of works arrangement, which I think is under condition 21. And what sits behind all of this is, of course, the statutory duties of South Ayrshire Council as the enforcing authority under the Town and Country Planning regime, and there are some arrangements in respect to the Scottish Ministers under the Electricity Act 1989. And effectively, when you put all that together, we're not sure what the role is of the planning enforcement officer. It would seem to us that it duplicates existing commitments under the conditions and indeed the statutory obligations of South Ayrshire Council. You're correct that there are, we understand there is some precedent for this condition not being accepted, albeit I don't have any specific decisions to hand. I'm not sure if that's something the other applicants can help with.
It was something that was referred to by the other applicants. Sorry, Carrick.
Thank you, sir. I was just going to say I could perhaps help with some examples of recent decisions where the condition has not been imposed within the core documents list. So the most recent would be the Acani extension decision of May 2023, which is CD 8.25A. There's also the Rothus 3 decision from October 2022, which is CD 8.6. The Clash Gower decision, also from October 2022, which is CD 8.4A. And the final example I have from the core documents is Gordon Bush Extension Section 36C decision, which is CD 8.18, and that was from November 2019.
Okay, thank you for that. That's very helpful. Did any of the other applicants want to add to that before it goes to council? Okay, council would like your comments on that particular request.
The primary reason for the council's request that I've seen is good practice to have a planning monitoring officer. It is included as one of the model conditions from the Heads of Planning Scotland's condition 12. It has been used regularly on major and section 36 applications. And yeah, it's seen as best practice. The difference though the council finds is that a planning monitoring officer, their role to an ECO is very, very different. They are covering all the conditions and clients and monitoring them, and not just ecological conditions.
Okay, does anybody have any comment back on those points? Oh, Mr. Bray.
It's maybe just to kind of ask the applicants whether or not through the construction environmental management plan that something like a quarterly reporting on planning conditions could be secured as an alternative means of the local authority getting information on compliance during construction. If applicants have got any view on that in terms of simply providing the local authority with a compliance report.
We've got no strong view on that. If that was felt to be a sort of halfway house, so then yes, we're not going to object to that.
Is that something that any other applicant has experience of, or the council?
I don't have specific experience of it, sir, but I agree that the approach sounds reasonable. We don't have any specific concerns with it.
That would just be a matter for us to consider then. Future. Okay, good. Mr. Reid.
Well, do the council have any sort of comments on that last matter?
It is something that could be included, but I think our preference would be to have it as a standalone. There is, I agree, some merit in having it included with the other condition, and it would certainly help council in terms of the resources and their planning enforceability as well.
So can I just clarify, you're still looking as a planning monitoring officer being your first, that is your position that you're holding? Right, okay, that's fine. Carrick?
Thank you, sir. We'd like an opportunity to take that away and consider it and revert towards the end of the hearing, if that's okay.
Okay. Moving on to traffic. Thing of that addition seems to be agreed between parties. Options to raise.
Mr. Reid, your reception is not very good at mine. I don't know if anyone else has experience in that.
Okay, I will try and get a bit closer to the microphone. Condition 40, I'll start again. Traffic and transport, construction, traffic works. Looks like the wording of that has been agreed across the parties and with the council. Is there anything else that anybody wishes to add? Okay, moving on to condition 41, which is traffic and transport, site and access roadworks. Again, the wording for this condition has been agreed between the parties. We have nothing else to ask on this matter. Are parties happy with that condition? The wording of it? Yeah. Okay, moving on to condition 42, which is compliance with approved plans and EIA. The applicants have indicated they consider this condition to be unnecessary and is general, and it presents difficulties in an enforcement perspective from all parties. So I'd like just the applicants just to kind of explain a bit more of their concerns with regards to this proposed condition. Mr. McLeod.
And we have a basic point on the necessity of the condition, and that's it comes back to the construction environmental management plan condition, which I think is number 15. I'm sorry, I'll just go to that. 16, beg your pardon. So that's on PDF page 22 of the table of conditions that have been submitted, condition 16. And you'll see in that, sir, that there's a wide variety of plans that need to be approved by the council before anything can happen. And all of those plans, which will form part of the CEMP, are to generally reflect the scope of the outlined CEMP in the schedule of commitments and the matters contained within it. So in essence, when the council approves the CEMP, all of the environmental commitments made by the applicant will be baked into what the applicant then has to comply with. So there is no need for a separate condition that requires compliance with the EIA report, because everything that we've said we will do will be baked into the approved plans.
Okay, thank you for that. Do any other applicants want to add to that?
Well, I think, sir, it's the same principle. I won't make reference specifically to the CEMP, but we obviously have a schedule of commitments, which was chapter 18 of our EIAR CD 3.21. the Knockcronal applicant's position is that any mitigation identified in there has been secured by way of other conditions, and therefore we're not sure what purpose this general condition serves. And I would agree with the comments from the Carrick applicant in terms of necessity. I think there's also some concerns in terms of precision and enforceability, which I think are already set out in the conditions schedule.
Okay, thank you for that. Mr. Hardy, do you want to add anything to that?
No,
Nope.
nothing, thank you.
Okay, thank you. Going back to the council then, can you sort of give us some sort of reasoning of why you think this condition is required?
Yes, sir. We have had a discussion and a review, and we accept there's a lack of preciseness within the wording of the condition, and it is captured elsewhere within the draft set of conditions. The one thing I would note is that it is included in the ACME decision, condition 6, I believe. But we do accept there's a lack of preciseness, and it seems to be well captured within, for example, the Kemp condition.
So my take from that, I think that conditions required to be imposed on application, any of the 3 applications.
Could you repeat that? Sorry.
I'm asking you whether you consider condition 42 is now required, or if you're happy.
We accept that it's a reason required.
So the council's accepting required condition. Just wanted to be clear and didn't want sincere mouth or in a wrong position. Okay. Okay, let's move on to section 43, which is television reception. I think we've got agreement across board from everybody for that, and we've no further questions on that one. I'm not seeing any hands going up. Moving on to condition 44, which is peak landslide risk. Mr. Bay, I think is still on. I think you had questions on this.
Yeah, it's really just how we deal with that matter. The council are looking at to a bit of a placeholder there in case further comments come in. Is the applicant expecting further comments, and is there particular matters that the council are expecting to see addressed, or is it just in case scenario something arises that you've left it there? For the council, I see someone nodding.
Yes.
So
yes, so I think it is just in case that was just a placeholder, as we say in the comments, just in case there are comments that result in a condition.
So it's not necessary, but we should be aware as reporters if anything came in that needs to be captured by condition. That's a reminder for us to do that. Is that a fair summary?
That's it, absolutely, yeah.
Mr. Scott?
Thanks, Mr. Bray. Appreciate that the council just confirmed that it's a placeholder, but a position of the Carrick applicant is that we've already had a response from Ironside Fire on behalf of the Scottish Government in terms of the peat landslide risk assessment, and it's acceptable. Therefore, we don't think it's necessary to continue holding a place for a condition to this effect. So can clarify if they've got any contrary information, but that's our fairly clear position on the matter.
Mr. Lopez?
So just to confirm, have Ironside Fire approved the peat landslide risk assessment? Is that what was said?
Yes, they have in September 2022.
I understood there was an updated assessment that was submitted.
My understanding was an update assessment, their initial response sought further clarifications, which was provided by WSP on behalf of the applicant, and following submission of those clarifications, they cleared the assessment, is our position. So.
With that, Mr. Lopez, would you be happy to give up the number 44 to someone else if they required it?
I think we would be, yes, like that's fine.
Mr. Reid?
Okay, thank you, Mr. Bray. Moving on to the final listed condition, which is 45 on aggregate strategy. Mrs. Leaven is going to pick up a couple of points on this condition.
Thank you. It's really just one point. I see that this is only being sought by the council in relation to Craiginmoddie, but following on from the transport hearing, I thought we had discussed that there might be a condition relating to all three applications. So I just wanted to get a view from the council on that first, and then maybe the applicants.
Yes, ma'am. Yeah, following the traffic and transport hearing session, we would favour commission being across all three development proposals.
Okay, so, and I see that Knockcronal, sorry, I think you have said that you don't agree with that. Could you say a little bit more about your response?
Of course. If we could start with one correction, which is in the final column of the condition schedule at pages 48 and 49. This is in response to the aggregate strategy, the need for an aggregate strategy condition. We say that the traffic effects of the project assume all material is transported to the site. I understand that's not correct, and that the traffic assessment assumes 50% of material is transported to the site, and that 50% will be secured from the 5 borrow pits that form part of the project. Notwithstanding that, we understand that the assumption of 50% of material being transported to the site is higher than expected based on the work undertaken to date, and that accordingly the traffic assessment by the applicants is precautionary, and its conclusions robust that the traffic effects associated with delivery of material to the site are not significant. On that basis, the applicant remains of the view that a condition that seeks to secure a commitment to the use of on-site material is unnecessary. We do express some further concerns with respect to precision and enforceability of this condition, given we cannot at this point in time make a firm commitment around where material is sourced from and what the percentages may be on-site or off-site. Having said all that, we are in the reporter's hands in terms of the need for this condition.
Thank you. I think it was specifically because you couldn't make that commitment at this stage that this sort of condition was considered helpful, to just allow the council to have a bit more say on that at a later date. And can I just clarify, so you're saying that the traffic assessment assumes 50%. Is that different from the evidence that you gave at the transport hearing, or?
I'll double check that, ma'am, if I may. I suspect in fact, I've just said confirmation. No, the answer to that is no. We did have our traffic witness at that session who undertook the traffic assessment. So that would have been on the basis of the 50% on site and 50% off site.
Okay, that's helpful. Maybe hear from Carrick as well, because you have a different view on this one also. Mr. MacLeod?
We do, ma'am. So our position is slightly different. I suppose just picking up on the point that Mr. Gibson made about the way that the assessment's been done, we assessed on the basis that 100% of our material would come from off-site. So just to be clear on our position on that. But the important thing for us in terms of this condition is that we say it's not necessary for our application in particular. And the reason for that, again, goes back to condition 16, which we touched on just a few moments ago. So our construction environmental management plan requires to include a whole series of management plans. One of those, which you'll find, I think, on page 23, is that we have to provide details of the size, location, and volumes to be extracted from borrow pits. So we do have to provide details of the borrow pits that we intend to use. And then link into that the beginning of the condition, which requires us to basically follow the schedule of commitments And as we've said in the final column related to condition 45, we have a commitment already built in to minimise the volume of imported material and to use borrow pits on site effectively where possible. So in essence, all of this will be covered already through the approval of the construction environmental management plan, and we don't therefore need a separate condition 45 dealing with an aggregate strategy separately.
Okay, thank you for pointing us to that. I mean, is that something, I'm just trying to look at it quickly as we're here, is that something that is picked up in the condition 16 for Knockcronal and Craiginmoddie? I'm not seeing that as I look at it just now, as a sort of alternative way of dealing with this. Does the council want to comment on that? So that's item 1N in Carrick's condition number 16.
Yes, ma'am. If it was to be included across all three, and if it was included within the camp, would be acceptable to the council. Again, like a lot of other conditions, as long as we feel that it's captured and can be delivered and is enforceable, and it would be acceptable to the council.
Okay, so I guess I should ask Knockcronal and Craiginmoddie just to respond to whether that would be acceptable in terms of adding that into condition 16. Similar provision.
I think I would want to revisit what is in our existing condition 16 in a little bit more detail, and also condition 13 on which is the borrow pits condition, as to whether there is already a mechanism in there that provides similar comfort. It's perhaps a point that we may need to take away. I'm conscious this is almost the last item on the agenda.
That's okay. I don't think it is covered in the borrow pits one, but certainly if you want to come back to us on that, you can. Does Craiginmoddie want to respond?
I think this, originated with us because we were listening to what the concern at the hearing, and that it aroused a lot of local concern. We put that away and we're responsive to it. There is a commitment to prioritising on-site use, so that's the reason we put it forward. And I think the wording for the addition comes from us. The council didn't have much input into it. So we think it's valuable. It's listening to the local community, whether that's a standalone condition or whether that goes into condition 16. I don't mind.
That's a helpful response. Thank you. Right, I don't think we need to probe any further on that. We've heard your points, unless Mr. Gray wants to add something.
I would just want to go back to some of the evidence we heard from the policy hearing. I think my recollection was, in terms of grid connection dates, they were largely similar across the three developments. So that would lead to the conclusion that the 36-month period for construction may be very similar. But is that an accurate depiction of what we heard from the policy hearing? Is that the grid connection dates were around 2027, 28, as I recall, so that we're looking at three proposals looking to build at the same time and connect roughly within a year or two, right, or within a year of each other. Just want to be clear that those grid connection times, you're happy to stand by them in terms of influencing your construction period.
Yes, that's our best information at the moment from us.
That just gives an impression of the likelihood of action commencing together. Thank you. That's all I've got, Mrs. Leedon.
I think that's all from me as well. Thank you.
Okay, I think that's back to me. That's all the conditions we have, the conditions table. Is there any, before we move on to another potential condition, are there any ones that we need to go back, pick up anything on at this point in time? Nope. Okay, I know there's other matters you might want to consider, but Mr. Bray, I think you've got at least one other condition that you might want to have a discussion on.
Just one, and it's a very small matter for Craiginmoddie. I think Scottish Water were looking for a planning condition with regard to a main, I think, that goes across the access road. If it were need to be crossed with the design agreed by Scottish Water. I'm not sure that's covered in the conditions, but if it is, please direct me to it, or if that issue is familiar with you. It was a request from Scottish Water, I think, for a condition to cover up the design of a access crossing over the water main.
The answer is I can't recall seeing the detail of that dealt with. So we're very happy with that. It is. I mean, it could be dealt with, I guess, it could be covered again in the construction management plan.
I think Scottish Water were looking for it to be covered anyway, so we'll potentially just leave that with you, because I'm sure Mr. Reid will be asking you to do further homework collectively, I'm sure.
Thank you, Mr. Bray. We've now come to the sort of end of all the conditions and the consideration of them. Are there any other matters in terms of the conditions that anyone wants to raise at this time?
There is just an additional condition that we might propose, and that's in relation to procurement. We had a discussion yesterday, you recall, in the policy session, and that was about keeping things local in relation to employment and supply chains. So I rather than put a suggested wording out now, I think if there's going to be some extra homework, if we circulate that amongst the parties and give a draft to the council and come back to you with that. But I didn't want that to get forgotten. So we are going to propose at least discussion of that. I think other parties had different views on enforceability, but our view is based on conditions which this client has had from other authorities, at least a starting point for discussion on that topic.
Okay, that's very helpful. In terms of homework, as it's been described, obviously we're looking to adjourn this and then reconvene after the aviation session. I'm conscious that with dealing with the three applications, the table that's the summary table with all of the comments in it has become somewhat perhaps complicated to read and work through. We've also made some sort of clarifications and updates as we've gone through the course of today as well. So I think it may be helpful if the applicants in the council could do almost a refresh of the conditions table, saying just basically identify where they think things are now resolved, and just tidying up the columns. I think that would be helpful for us when we go back to look at it. We may still have some other issues or questions that may arise. We've also got the period we've got to take on board the comments on the aviation conditions, but rather than wait till that very late point to finalise it, I think there would be some benefit in trying to at least update the table, particularly bringing in on board the comments that came in terms of the later submissions and the riders that were there as well. So rather than having things in different places, just to try and pull everything together, that's what we'll be looking to do in principle. Mr. Callan, you have your hand up.
I do, sir. I was just wondering, would it cause an awful lot of hassle if we part of the tidy up as we look at reordering the numbers as well, just in terms of keeping all the traffic and transport related conditions together and all the ecology, because they're in different places as per the draft set of conditions. But I'm obviously aware that the aviation hearing session and subsequent hearing on their aviation conditions hasn't been concluded.
The views of the applicants on that suggestion?
I think renumbering, yes, I think it is essential, because there are also some conditions which have been agreed to be unnecessary. So there are going to be deletions. And I also think it might be helpful to put the fairly lengthy operational noise condition at the end, which is pretty standard fare. So my view is, if we're looking at this, Mr. Khan, if council's going to do that, I would have thought, yes, absolutely, we do need to do that. Probably reorder, take the noise condition at the end. You might, I don't know how you do that in terms of numbering, because you may then need to do to look at it again. I suppose you could use that. You could put the GPA conditions at the very end, so you could use the operational noise condition up to that point. That could remain fixed, and then depending on what happens to the GPA conditions, I suppose you could take those out. So it's just a practical suggestion to get as fixed a list as we can.
Okay. Any other applicants have any comments on that? Mr. McLeod?
No, just to say we're very happy to do a full tidy up exercise, and we'll get something more manageable to you in due course.
Okay. Mr. Bray, you have your hand up.
I think in doing that, I would certainly suggest grouping them and giving them titles, because that generally, as you'll have seen from some appeal decisions, the conditions are grouped and given general titles as a helpful aid. So if you were to group them together and give them a title within each, like a title for the group, that is, not the individual condition, then that would help us towards the end of our process, I think.
Okay, so I think all parties seem to be agreeable in principle to do that. And in terms of the timescale, we've got to write out on some other further written submissions. So I think we will include a timescale within that proposed to try and get that document in sooner rather than later, so we've not lost everything that we've discussed today. Is that fine with everybody? Yes, I'm seeing nods. Okay.
So, can I just yes,
just
to be clear, did it say, Mr. McLeod, were you sounded as though you're happy, are you, to have first stab at a tidying up exercise? Is that just to make sure?
Sorry. So yes, happy with the tidying up exercise, and as Mr. Bray indicated, sort of using the headings, moving the noise condition, I should say, that all seems to make perfect sense.
Yes, it wasn't so much that, it was exactly just who was going to do.
Mr. McLeod seemed to, I'm not going to volunteer, but he seemed to indicate a tidying up exercise could be undertaken. Mr. McLeod, I think you're on mute.
I'd assumed that because Mr. Hardy had a new condition on procurement, that his team might like to take the first stab at it.
We don't mind. Just all I want to be clear is who is going to do it.
Okay. I will leave it for the applicants to amongst themselves to sort out who's taking the lead. Obviously, the council will input accordingly. Mr. Gibson, is that a volunteering hand?
No, it looks as if that matter's been resolved, so I won't rock the boat. No, it was just touching on your final point there, sir, in terms of getting council input and making sure we factor in sufficient time for the council to comment on any updates before we make that submission.
Okay, that's fine. Mr. Hardy, are you happy enough with that?
Yes. So just in terms of timescale, sorry, can we just go back on that when?
I think we were, well, we've got further written submissions that we are looking to request, so maybe I'll tie in with that particular timescale. Mrs. Leven, did you want to say something?
It's fine. I think you're going to cover it.
Yeah. So that would be what we'd be looking to do now. I'll need to ask Mrs. Leven for the timescale, because I don't have it down.
So July, I think, was.
Yeah, we're looking at the 21st of July to get things in by.
So does that include?
Sorry, Mr. Reid will probably go on to now explain how that might tie in with the closing submissions timescale, so that it'll hopefully
it wasn't that, Mark. I was going to ask about, because there was also discussion of a 21-day period to deal with the noise submission, which came in from South Straighton. So 21 days wouldn't time with 21st of January. It may be that's going to be 4 weeks, say, from now, rather than 3. So just want, as long as we're clear, that's all I'm asking.
Oh, Mr. Bray, hand up.
Happy to clarify that particular amendment that we talked about to the existing further written procedure on noise, I think that can tie in with that 21st of July if everyone's agreeable. So that gives it more than the 21 days. So once we confirm everything in writing that Mr. Reid is going to tell you in a little minute, then that further written submissions on noise would tie in with that period. So that would allow whoever's lying on the beach to continue to do that until he comes back.
Okay, are we all crystal clear of what we're doing with the conditions now? Good, good. Okay, so really just in terms of some concluding remarks, as set out in a recent email, we're happy to discuss the approach to closing submissions and case summaries today. However, we will wait the conclusion of the Craiginmoddie LVIA inquiry before finalising our plans in writing. So we'll wait till the close of that, which will either be on Thursday or Friday of this week. The note of the first PEM said that the closing submissions would be made within 28 days from the close of the oral sessions. The inquiry timetable has changed, and we have a wide range of sessions across 3 proposals, and we're also approaching the summer holidays. So what we're proposing is we'll be now looking to ask for closing submissions in 2 stages. The first of these, we would ask for closing submissions on all matters excluding aviation, and then we would have closing submissions on aviation alone. We propose that the initial closing submissions are from parties by the 28th of July, with closing submissions for the applicants by the 18th of August. We plan for the closing submissions after the aviation inquiry to be completed quickly and within a 2-week period. We will be confirming these timescales in writing after the Craiginmoddie inquiry and no later than the 30th of June. At that time, we plan to send out the template for the summaries of case, and that will be for the landscape and visual matters. These are to be returned at the same time as closing submissions, and these will be required from the council and the applicants only. So the summary of case templates will also be sought for aviation in due course, but not sought for any of the other topics covered. And just as we're mentioning, for your information, we will be having a further round of written submissions on a few matters. The further written submissions request will be sent out again no later than the 30th of June and will be completed by, as Mr. Bray indicated, the 21st of July. So that's current timetable, primarily to try and get these things enough time to allow them to happen, but to also fit in with our availability over the summer period as well. So are there any questions on any dates at this time? Mr. Armstrong.
Sorry, just to clarify two points. Firstly, just in relation to the summary of cases, I think it was initially anticipated it would be for the policy and also the landscape and visual. I maybe missed it. And what are you just wanting one for the landscape and visual now, and not for the
what we're looking for now is just for the inquiry sessions. So the 3 landscape and visual inquiry sessions and the aviation inquiry session. These are the only ones we will now be looking for some case summaries for.
And the second point was that in the note in that template for the summary, it says a total of 2,000 words. Is that 2,000 in total, including all aspects of that document, or is that 2,000 in relation to the conclusion, or is it everything, including the sort of summary of each component of the set out in the template?
It's a good question, and I'll have to reread the guidance notes myself because I don't know the answer immediately, and I don't think Mr. Bray or Mrs. Leven will know the answer to that, but we will certainly double check and come back to clarify that position on the case summaries.
Obliged. And one other point from me at this stage, obviously, I'm going to be doing slightly more submissions, closing submissions, than some of the other parties, and it would be helpful to get clarification if you're content with cross-referencing from one closing submission to the other, or whether you'd prefer them all self-contained closing submissions. I mean, happy to do it either way, but it's just avoiding sort of repeating the same thing 3 times. If, for example, certain matters that apply to all 3 are dealt with in one, do you want that repeated in the other 2? Can parties just cross-reference to one submission?
Okay, I think that's a question that we will probably need to have a little discussion. Oh, I've got 2 hands up. Mrs. Lee, will let you go first.
Oh, crikey, I hope I don't cut across Mr. Bray, but I was just going to say we are obviously preparing 3 separate reports for each of the individual proposals. So I think you would need to sort of have them self-contained with that in mind. That's getting a thumbs up from Mr. Bray.
I think that's to allow ministers to consider each report on its own merits and to see the position of the council on each application clearly. I'm afraid, Mr. Armstrong.
Okay, hopefully that answers the question. Is that all your questions, Mr. Armstrong?
Yes, sir.
Okay, that's fine. Are there any questions from anybody else on that matter? Okay, we've covered the updated list of conditions. I don't have anything else to add, Mr. Bray.
No, nothing to add. You'll be glad to hear.
Mrs. Levin?
No.
Nope. So on that, I would just like to thank everybody for participating today in a constructive and helpful manner to work through the detail of all these conditions. It's very helpful to us to help to clarify some of the outstanding matters. The next session is tomorrow, and that's Craiginmoddie, Wind Farm Landscape and Visual Impact. And that will commence tomorrow morning at 10 a.m. With, I think, Mr. Hardy, Craiginmoddie. Does anybody have anything else?
Going to be Mr. Cook rather than me, but yes.
Okay. Right, thank you for that clarification.
Hand up.
Mr. Lopez, do you have your
Armstrong.
Mr. Armstrong? Sorry, there's no yellow hands. I was following the yellow hands there. No questions from anybody else?
No questions.
Okay, right. Well, on that note, thank you all for your participation today, and that adjourns our meeting. Of course, we will be reconvening in September on the date to be agreed to consider the aviation conditions. So thank you all for your contributions.